Good morning, everybody, and welcome to the joint convening of the Energy and Power Subcommittee and the Oversight Investigation Committee. And I join my distinguished Subcommittee Chairman, Mr. Whitfield from Kentucky, in convening this joint legislative hearing. We have two bills before the subcommittee. I'll be addressing my opening statements to the No More Solyndras Act, and then relinquishing the chair for the first panel to my colleague, Mr. Whitfield. And I yield myself 4 minutes for my opening statement. With Chairman Upton, I'm proud sponsor of the No More Solyndras Act. The Act is a product of an 18-month investigation by the Subcommittee on Oversight Investigation. Today marks a turning point in this investigation. We gather to consider a bill that will fix the problems we uncovered during our investigation. The Solyndra investigation and the introduction of the No More Solyndras Act is a great example of how congressional oversight should work. Ask tough questions, collect all the facts, identify the problems, and offer legislative solutions. Solyndra was the first recipient of a DOE loan guarantee under Title 17 of the Energy Policy Act and a poster child for President Obama's stimulus-driven green energy program. It was also the first stimulus-backed recipient of a DOE loan guarantee and the first to file for bankruptcy just 2 years after the loan closed and 6 months after DOE restructured the loan and subordinated its interest to Solyndra's private investors, all but ensuring taxpayers won't see a dime. 3 of the first 5 companies which received loan guarantees issued by the Department of Energy loan guarantee program have now filed for bankruptcy, and hundreds of millions of taxpayer dollars will never be recovered. The reason the committee initiated the Solyndra loan guarantee investigation are simple. The Democrat majority in 2009 and 10 conducted zero oversight of DOE's loan guarantee program, even after it received a massive injection of funding from the stimulus. Just 1 year after receiving the first loan guarantee, trumpeted by DOE in the White House, Solyndra closed its manufacturing facilities and laid off hundreds of workers. On behalf of American taxpayers, we have a duty to figure out what went wrong with the Solyndra loan guarantee and whether the program was properly managed. The subcommittee's investigation has been thorough and methodical. The committee requested, received, and reviewed documents from every executive branch agency connected to Solyndra and interviewed more than a dozen administration officials who played key role in the loan guarantee. Some members of the minority have contended that the investigation of Solyndra only showed that the loan guarantee was risky. This investigation has shown far more than that. For example, the investigation has shown that several red flags were raised in 2009 by DOE and OMB staff about the company's financial condition and the market for Solyndra's products. But the administration ignored these warnings. DOE failed to consult with the Treasury Department, as required by the Energy Policy Act, prior to issuing a conditional commitment to Solyndra. The administration's desire to highlight the stimulus impacted the quality of OMB's review and resulted in DOE rushing the loan guarantee out the door. DOE failed to adequately monitor the loan guarantee, blindly writing checks to Solyndra as the company hemorrhaged cash throughout 2010. DOE restructured the loan guarantee in early 2011 and then, in violation of the Energy Policy Act of 2005, offered to subordinate its repayment position to Solyndra's private investors in the event of a liquidation. OMB staff raised serious questions about the legality of the restructuring and whether it would improve the government's recoveries after immediate liquidation. Treasury played no role in reviewing the restructuring, but advised DOE to consult with the Department of Justice about the subordination, which DOD refused to do. And right up to the bankruptcy filing, the administration was willing to take extraordinary measures to keep Solyndra afloat for political reasons and ensure that the first loan guarantee was not a failure. With Chairman Upton and other members of the O&I committee, we are sponsoring the No More Solyndras Act to make sure, my colleagues, that these mistakes and misguided decisions never happen again. And I give the balance of my time to the chairman, Mr. Whitfield. 6 minutes for Mr. Whitfield.
Well, thank you, Mr. Stearns, and I'm delighted that the Oversight and Investigation and the Energy and Power subcommittees are joining together today in this important hearing. Everyone in America is very much aware of Solyndra. And Solyndra is troublesome for many reasons. First, the federal government chose to give $500 million loan guarantee to a company so inept that it has gone bankrupt and left the American taxpayer holding the bag. Second, the fact that George Kaiser, a major investor in Solyndra, was also a major fundraiser for President Obama, cast a questioning motivation of this loan. And Solyndra is not the only company that received a loan guarantee that has gone bankrupt. You've got Beacon Power, you've got Abound Solar, and there are others. All things considered, there's more than enough evidence to declare this program a failure. In fact, some people have said it really was a slush fund for the president. It's been a failure for a lot of reasons. One, lack of transparency. Two, costly for taxpayers at a time when we have a horrendous federal debt and annual deficit. And then the fact that in the case of bankruptcy, the lawyers of Solyndra and the lawyers for the Department of Energy and the administration agreed to subordinate the taxpayers so that the private investors would get their money back first and the taxpayers last is really almost unbelievable. And then what role did political connections play in the receiving of these loan guarantees? The Solyndra case certainly raises that issue. And the loan guarantee program, as far as we know, has not developed many technological breakthroughs at all that would benefit the American people. Now, the administration talks a lot about, oh, we've created 4 million new green jobs. And yet Chairman Issa and others have had hearings, and when you found out what is declared or what is defined as a green energy job, someone merely filling up a bus with fuel, that's considered a green job now. So they didn't create new jobs, they simply changed the definition of a green job to mislead the American people. And that's precisely what has been done in this instance. And so this legislation, No More Solyndras Act, introduced by Chairman Stearns and Chairman Upton, is vitally important to protect the American taxpayers that we pass and we adopt this legislation. And then another bill that we're going to be considering today is the Smart Energy Act, which was introduced by Mr. Bass of New Hampshire. And we all know that in order to conserve energy, there are a lot of different ways to do it. One is through efficiency. And Mr. Bass's bill focuses on the government becoming more efficient in its use of energy. And so I want to applaud him for that legislation. And I would also just point out that we've had major innovations throughout the history of our great country. You think about Alexander Graham Bell, Henry Ford, the Wright brothers, Bill Gates, Steve Jobs, and others. And yet they were able to develop these new technological breakthroughs with private dollars and not government money. So I'm delighted we're moving on this program. At this time, I'd like to yield time to the chairman, Mr. Fred Upton.
Well, thank you both, Chairman. We all want to see innovations and breakthroughs in the energy sector, and I believe that the federal government can play a constructive role in encouraging them, but when a Department of Energy program is not delivering on the goal while costing hundreds of millions of dollars, we owe it to the American people to pull the plug. And unfortunately, we've reached that stage with the Loan Guarantee Program, which is one of the reasons why I co-authored the No More Solyndras Act. Again, I want to thank Mr. Stearns, Chairman of the Oversight Investigation Subcommittee, for his very hard work, determination in getting to the bottom of the story. Let's not forget that when our team started the investigation, both the administration and the company itself strongly denied that there were any problems whatsoever, and right up until its bankruptcy last summer. Solyndra was advertised to the American people as a stimulus success story. Some even accused us of witch hunts and fishing expeditions. I believe there is a legitimate role for the federal government in funding basic research, but with bankruptcies starting to pile up, our message to the American people has to be clear. There will be no more Solyndras. Asked unanimous consent. My full statement to be put into the record. I yield the balance of my time to Mr. Barnes.
Thank you, Mr. Chairman. I think this is a positive step today. The fact that we've got a draft bill on no more Solyndras, it's a good bill. I think Mr. Bass's bill is also a good bill. I would slightly diverge from the party line to say that I don't necessarily think we have to throw the baby out with the bathwater. I do think we can reform the program, these green energy loan programs, without totally terminating them. And I hope in the process of this legislative hearing that we could discuss some ways to have a win-win on both sides. Keep the program, but make them more open and transparent. Put some penalties in for non-performance. And as the Chairman's and Mr. Stearns' draft bill does, make it absolutely clear that they have to work with the Treasury Department, and if they don't, there'll be penalties. So in any event, I want to commend Mr. Upton and Mr. Stearns for their draft bill, and also Mr. Bass for his bill, and I look forward to a productive hearing today.
Thank the gentleman from Texas. Now recognized for 10 minutes, the ranking member, Mr. Gett from Colorado.
Thank you very much, Mr. Chairman. I yield myself 3 minutes.
So recognized.
Mr. Chairman, since I've joined this committee, I've learned a very simple lesson. Good oversight results in good legislation, and in contrast, biased and partisan oversight results in biased and partisan legislation. And the No More Solyndras Act, the legislation we're considering today, proves that lesson. Let me be clear. The loss of taxpayer dollars in the Solyndra bankruptcy is a serious problem. We should have conducted a full and fair investigation so we could find out what happened and make sure it doesn't happen again. Instead, the DOE and Solyndra oversight have been designed to make cheap political points in an election year instead of following the evidence where it leads. Unfortunately, Mr. Chairman, I have to respectfully disagree with your characterization that this committee has conducted a thorough investigation. Despite our requests, there were no hearings to understand what U.S. policies are necessary to ensure that U.S. manufacturers can compete in the global clean energy market. There's been no testimony from the largest private equity investors in Solyndra to understand why the company attracted over $1 billion in private capital. We've refused to investigate the DOE loan guarantee programs loans to nuclear projects, and we've refused to invite DOE witnesses to discuss the legal and financial rationale behind the subordination of the Solyndra loan guarantee. The oversight that the minority asked for in these requests would have provided the proper factual background for legislative action to actually improve the DOE loan program. Instead, the majority has conducted a political investigation, ignoring the benefits of the DOE program, making a series of inflammatory and misleading statements, blocking the release of exculpatory evidence, and abusing witnesses who invoke their Fifth Amendment privileges. Given the inadequacies of the committee oversight, it's no surprise to me that this legislation is also problematic. It's a political statement rather than a serious policy proposal. It begins with 6 pages of findings, including the unsupported statement that the review of the Solyndra loan application was, quote, driven by politics and ideology, end quote. Mr. Chairman, this statement's not supported by our committee's oversight work. In fact, our investigation revealed the opposite to be true. The key decisions on the loan guarantees were made purely on the merits. The discussion draft ignores the findings and the recommendations of independent consultant Herbert Allison, who conducted a thorough, detailed analysis of the program. He found that it was largely successful and stable, but he did make a series of recommendations to improve performance and program management. DOE is working to implement these recommendations, but the legislation ignores this fact. Mr. Chairman, I would have loved to have worked on bipartisan legislation to improve this program, just like I would have liked to have worked on bipartisan oversight of the program. But instead of that, we had a series of very bipartisan hearings, which have led to this very partisan hearings, which led to this very partisan legislation. And I hope we can shift course after that and change this legislation in a bipartisan way. With that, I yield 2 minutes to Mr. Dingle, the Chairman Emeritus. Mr.
Chairman, I have a fine opening statement, which I'm going to ask to be put in the record. We have been suffering through this on many occasions, having a wonderful set of hearings, totally unrelated to facts, but having about the same reality as Alice in Wonderland, on a bill that was supported strongly by the leadership and the members of the Republican Party. And now we hear how we're going to correct this whole legislation by a new piece of legislation. Committee, under the leadership of my Republican colleagues, has been blundering around, crashing into walls, finding nothing, issuing the most inflammatory press releases imaginable, and thinking apparently that the constant repetition of this nonsense is going to make somebody believe it. The harsh fact of the matter is that nothing wrong has been found, excepting that a loan failed because the Chinese cut the prices of thin film electrical generating stuff that draws its power from the sun. And so my Republican friends are crashing around, issuing press releases that sound like Jules Verne in their imagination, but demonstrating the wisdom and vision of an earthworm. And so now, this morning, we're up to repeal legislation which afforded the United States some opportunity to see to it that we could compete with Chinese, Koreans, Japanese, and others whose governments wisely and prudently fund their national efforts to develop new systems of energy use. And I would just note that the Volt, which is a superb piece of American engineering, was driven just recently out of an American factory using American technology on batteries which were manufactured, guess where, in Korea, because the Koreans are stealing the technology that Americans have taken because they have government support. Same thing is true with regard to the Chinese. So let me simply observe, Mr. Chairman, this is a prodigious waste of time, waste of opportunity, loss of opportunity for the United States to really become competitive. And it's my hope that the Republicans will finally realize that this is a political exercise and not something which is conferring any good upon the United States. I thank you.
I give that balance of our time to Mr. Waxman.
Mr. Chairman, my colleagues and members of the audience, Mr. Dingle is absolutely right. This is a hearing for politics. That's all it is. And I guess it's an election year, so we can excuse it. But this nation faces an urgent energy challenge. The recent wildfires, drought, heat waves, extreme weather events tell us that we must act to address climate change. These are exactly the types of extreme events that scientists have been predicting and that Congress has been ignoring. According to the National Oceanic and Atmospheric Administration, more than 40,000 hot temperature records have been set this year. At the end of June this year, more than 100 million people in the U.S. were in areas under extreme heat advisories. 2/3 of the country is experiencing drought. More than 2 million acres have burned in wildfires this year. But we need to act to reduce carbon pollution, and there are a range of options for doing that, from putting a price on carbon to sensible regulations to incentives for clean energy. But House Republicans oppose every potential solution. They say no to market-based solutions like cap and trade, no to cost-effective regulations, no to loan guarantees or financial incentives for clean energy, even if they would improve our nation's global competitiveness. And they even say no to simply understanding the problem. Representative Rush and I have written to Chairman Upton and Chairman Whitfield 15 times this year to request hearings on various climate change reports and topics, and we've yet to even get the courtesy of a response. Denying the science and refusing to recognize the laws of nature is completely irresponsible. Regrettably, today's bills are just more examples
of the same. No one should mistake the loan guarantee bill we'll be considering for a serious effort at reforming the program. In fact, most of the bill is composed of inaccurate and misleading congressional findings. I'm sorry Solyndra happened. We lost $500 million. That's a shame, but that's why loan guarantees are provided, because these are risky enterprises, and not all of them are going to succeed. But there has been no showing of wrongdoing by anybody in this administration due to the Solyndra loan loss. No showing of wrongdoing, despite the claims being made by the Republicans. There's no evidence for it. So what are they proposing? Legislation that would, they say, end this loan guarantee program, but instead provide billions of dollars still to be used. But they do it in a way that would ignore the best possible technologies. They create a winner's list of about 50 projects that are eligible, and then if any new innovative idea comes up in this year or next, they wouldn't even be eligible to seek a loan guarantee. Even technologies Republicans claim to support are abandoned. If an application for a small modular nuclear reactor or a next-generation nuclear plant is submitted, DOE is required to reject it. I don't think this is a way forward. I don't think this is a way to address the problems. Even energy efficiency, which is essentially part of any serious plan to address climate change, it's a low-hanging fruit. It reduces pollution while saving Americans money and creating jobs, whether it's building codes or appliance standards or industrial efficiency improvements. We should be doing much more in this area, and yet we're not moving forward in any energy efficiency opportunity. Both of the bills we'll be considering have serious flaws. We need to step outside the bubble of being in Washington and being consumed by the quest for political power, and recognize the havoc that extreme weather is causing around the nation, and develop together solutions to climate change and the real energy challenges facing our nation. Thank you, Mr. Chairman.
I thank the distinguished ranking member of the full committee, and I would just point out that it took us almost 8 months since my subpoena back in November to get the information, and finally the White House was compliant, but this was an arduous task, and we felt very methodical. With that,
Mr. Chairman, we're having more time go by where we're not even getting answers to our letters from the leaders.
Well, we're moving forward, Mr. Waxman, and we appreciate your concern. At this point, the opening of the first panel will be handled by the chairman of the subcommittee on power, energy and power, and so with that, I turn the gavel over to Mr. Woodfield.
Thank you, Mr. Stearns, and I want to welcome the members of the first panel. We appreciate your taking time to be with us this morning on what we consider a very important issue, because our responsibility to the taxpayers is very important, particularly at a time when we have a gigantic federal debt. Our two witnesses on the first panel are first Mr. David France, who is the Acting Executive Director at the Loan Program Office at the U.S. Department of Energy. And the second is the Honorable Dr. Kathleen Hogan, who's Deputy Assistant Secretary for Energy Efficiency, Office of Energy Efficiency and Renewable Energy at the Department of Energy. So once again, thank you for being with us. We appreciate it. I'm going to call on each one of you to give a 5-minute opening statement, and then at the end of that time, we'll give members an opportunity to ask questions. So, Mr. France, we'll begin with you. You'll have 5 minutes for an opening statement.
Chairman Whitfield and Stearns, ranking members Rush and DeGette, and members of the subcommittee, thank you very much for the opportunity to testify before you today. My name is David France. I am the Acting Executive Director of the Department of Energy's Loan Programs Office. In the way of an introduction, I am a career member of the Senior Executive Service of the U.S. Government. I was the first employee of the LPO in 2007. Prior to joining the department to stand up the LPO, I previously served over 10 years with the Overseas Private Investment Corporation in a senior management project finance position, underwriting and structuring major energy infrastructure projects around the world. Prior to this government service, my 40-year career has been entirely devoted to project finance in the private sector, and previous to that, I served as a U.S. naval officer, and I am a Vietnam combat veteran. At the onset, I want to particularly express my thanks to all of you and your respective staffs for your continued interest and attention to the program over the past 5 years. It is important to reiterate the point that this was a program initiated by the U.S. Congress with strong bipartisan support in 2005, and we have continually welcomed suggestions from the committees during the course of the development of the LPO. Before highlighting the progress we have made over the past 5 years, I would also like to acknowledge and commend the LPO staff for their unswerving commitment and diligent work associated with the accomplishments of the program. The staff is one of the finest project finance teams assembled in the world today, and its record over the past years is unprecedented by world standards. I would hasten to add that the GAO in its recent audit of the DOE loan programs guarantees acknowledged that commercial lenders interviewed by GAO stated that LPO's underwriting and due diligence standards are as rigorous as or more rigorous than those in the private sector. It is noteworthy that in 2011, the Department of Loan Programs Office was recognized as the largest single source of debt financing for clean energy projects in the United States, public or private. This occurred during a period of time in which private lending market did not have the ability or willingness to finance the innovative and large-scale clean energy projects that the LPO supports. In addition, 2 transactions were recently recognized by their exceptional structure by preeminent journals in the project finance field as deals of the year. At this time, the LPO has committed or closed $35 billion in direct loans or loan guarantees, which finance nearly 3 dozen projects to support more than $56 billion in total project investments. When it ended on September 30th, 2011, the 1705 program included a portfolio of over $16 billion for 28 renewable projects. Collectively, the LPO projects are expected to support over 60,000 jobs. While we have faced challenges in our activities, we have always made financial decisions based solely on what we believe at the time will result in the best outcome for the United States taxpayer. We also have reacted on a continuing basis to apply fundamental lessons learned. As I emphasized in my written testimony before you, our work has had substantial and far-reaching impacts that are beyond the contributions of the projects themselves. Whole new sub-industries have been fostered through the supply chains. With respect to the specific legislation, the administration is currently reviewing it and has not reached an official position. While we certainly share the goal of protecting taxpayer dollars, that is always our primary objective in the program, the Department has concerns that this legislation will not accomplish that goal. In fact, we are concerned that this legislation potentially could have unintended consequences that would limit our ability to fulfill the mandate that Congress gave us and could potentially put taxpayer dollars, frankly, at risk. Additionally, the legislation could lead to duplication of interagency efforts and add costs. Let me express our concerns in a little more detail. First, the legislation would prohibit the Department from making any loan guarantees on applications received after 2011. This provision would make it difficult, if not impossible, to make use of remaining loan authority provided by Congress, particularly in the areas of the fossil energy. Moreover, going forward, the Department would increasingly be unable to guarantee loans with the newest and most innovative technologies, particularly in the area of nuclear and renewable projects. Second, the legislation would extend the consultative role of the Treasury Department when originating and restructuring loans. Each agency in the loan guarantee process plays a particular role based on its existing interests and expertise. The legislation's additional requirements on the Treasury Department may increase the transaction cost to the government by requiring duplication of responsibilities. And I would do note that we have worked very closely and on a continuing basis with the Office of Management, Budget, and Treasury on each transaction throughout the approval and closing processes to best utilize their specific areas of expertise. Finally, The legislation would prevent the Department from subordinating our loans during a restructuring. This provision would weaken the taxpayers' investments by eliminating a tool that may be the best option for saving projects at risk and, in fact, protecting the taxpayer. Herb Allison, who conducted an outside review of the Department's loan portfolio and has decades of experience in the financial world, stated in his testimony before the Senate Energy and Natural Resources Committee that if the paramount issue is taxpayer recovery, he believes the Department should have some flexibility, and I emphasize flexibility, to subordinate when necessary. In conclusion, Mr. Chairman, with your support, we look forward to continuing to promote opportunities for the United States to stay at the forefront of innovation in clean energy generation and manufacturing while supporting projects that create jobs and reduce pollution. In administering the Title 17 and ATVM programs, we are continuously striving to improve our systems and processes in order to manage loans, transactions, and portfolios in the most effective and efficient manner possible, all the while with the interests of the U.S. taxpayer as our foremost concern. Thank you very much again, Mr. Chairman, for inviting me here today. I look forward to responding to your questions.
Thank you, Mr. France. Dr. Hogan, you're now recognized for 5 minutes, and there is a little box on the desk that when it says red, that means stop, but I won't stop you immediately, but it'll give you some semblance where you are. Thank you.
Thank you. Chairman Whitfield and Stearns, ranking members Rush and DeGette, and members of the subcommittee, I do thank you for the opportunity to discuss the Department's efforts to improve the energy efficiency of the federal government and the industrial sector, and to comment briefly on the legislation being considered by the committee today. President Obama's all-of-the-above energy strategy is designed to reduce our dependence on oil, save businesses and consumers money, make us more energy secure, protect our environment, and position the United States as the global leader in clean energy. And in pursuit of these goals, DOE supports a broad range of efforts, research and development for new advanced energy technologies, works to accelerate the adoption of efficient products and services, and also assists the federal government in leading by example in these areas. We do want to thank you for your efforts and do support many provisions of the Smart Energy Act, though we would also like the opportunity to provide technical assistance in several places to offer greater clarity or adjustments based on what we know is already well underway. I will now go on to talk about DOE efforts related to the draft act. First, I want to highlight that the federal government is making great strides, leading by example on energy and sustainability goals set by Congress and the executive branch, and indeed performance contracting is very important to these efforts. We have executive orders and enacted legislation such as EPACT 05, ESA 2007, which establish a number of goals for energy intensity, water intensity, greenhouse gas reductions, fleet energy use, renewable energy, sustainable procurement, and data center efficiency. DOE's Federal Energy Management Program, or FEMP as it's known, provides assistance across the government to help achieve these goals cost effectively, as well as reporting on progress. The results to date are significant. We are seeing reductions in energy use per square foot by about 15%, reductions in water use intensity by more than 10%, and use of renewable energy sources for more than 5% of electricity. And indeed, performance-based contracting has been important to much of this progress. Since 2006, FEMP has assisted federal agencies in saving over $5 billion in energy costs over the average life of the efficiency measures implemented through these contracts, and is now working with federal agencies to help them achieve the President's directive under the Better Buildings Initiative of engaging in an additional $2 billion or more in performance-based contracting. Here we look forward to working with the committee to see how we can continue to use this mechanism as effectively as possible. I also would like to highlight what we're doing with electric vehicles. They can certainly make a tremendous contribution to energy security, environmental and economic objectives, and the federal government is doing a lot here. While DOE supports a broad portfolio of vehicle technology work, we do also have a strong emphasis on electric vehicles. Their broad use can have a big impact on reducing our dependence on foreign oil, provide stable and low fuel prices for American families, while they also have the convenience of just plugging in at home, and they can reduce the overall environmental impact of transportation. Across the administration, EVs and charging infrastructure is being adopted into the federal fleet. Clearly, there is more opportunity, particularly as the costs for EVs continue to come down, and we are available to work with the committee to figure out the best approaches for continuing to advance EVs in the federal fleets. We also do important new work to bring down the costs of EVs. We have the new EV Everywhere Grand Challenge, where DOE is working with the public and private sectors to set aggressive goals to develop the next generation of vehicle component and charging technologies to assure cost-competitive plug-in electric vehicles. This initiative also aims to put the U.S. in the lead to manufacture and export the next generation of advanced plug-in EVs and its components to create high-paying American manufacturing jobs. Continuing on the theme of the importance of American manufacturing jobs, we are also working to strengthen the nation's manufacturing sector in ways that can create more jobs and enhance U.S. competitiveness. The DOE's Advanced Manufacturing Office supports high-impact manufacturing and materials research and development. We work and coordinate well across the National Institute of Standards and Technology, NSF, the Defense Department, and other government agencies. And we are particularly prioritizing those cross-cutting technologies that are common to many clean energy technologies and really many industries, so that we can engage in these high-impact areas. We also are working with today's industry to help them save energy and increase profitability. One example is our Better Buildings, Better Plants program, where energy leaders agree to set goals to improve their operation energy use by 25% or more over 10 years. This program now includes 110 companies representing 14,000 plants across more than 20 industries, and they are making great progress. Finally, I just want to comment on our continued support for combined heat and power development. CHP is an efficient and clean approach to energy generation. Instead of purchasing electricity and burning fuel separately, you can do it together with much higher conversion efficiencies. Recognizing the benefits of CHP and its current underutilization in the U.S., we are focused on accelerating the deployment of new and cost-effective CHP, for example, through our regional clean energy application centers, where we assist in transforming the market for CHP, waste heat to power, and district energy technologies throughout the country. The centers focus on assessments, education, outreach, and technical assistance. So just in summary, we are making a lot of progress, improving the efficiency of buildings, the federal sector, vehicles, industries, but there also continues to be large additional opportunities in each of these areas where we can have important impacts for improving security, saving energy, and protecting our environment. We really appreciate the opportunity to be here and happy to answer your questions.
Thank you, Dr. Hogan, and thank both of you for your testimony. I'll now recognize myself for 5 minutes for the purpose of asking questions. Mr. France, when I am back in my district and I talk to civic clubs in Kentucky and elsewhere, and when they find out that I'm involved in the energy policies of the United States government, inevitably this question comes up about Solyndra. It's almost becoming an example of many people's feeling of incompetence in government, and you know there's a lot of anger out in the public anyway about taxpayer dollars. And in your testimony, you indicated that protecting taxpayer dollars was one of the primary responsibilities that you feel as the acting director at the LPO program. And so I want to ask you some questions regarding this subordination issue. Now, Director of the OMB at that time, Jacob Lew, sent out this circular A129 guidance document to executive departments, which basically prescribed policies and procedures for designing credit programs, including the loan guarantee program. And it specifically said the government's claims should not be subordinated to the claims of other creditors because subordination increases the risk of loss to the government and to taxpayers. Now, Circular A-129 would apply to DOE and the loan guarantee program, wouldn't it?
Yes, sir.
And since it does apply and it specifically says what it does, how did you all feel like that you could subordinate taxpayers to the interests of private investors?
Mr. Chairman, first, I'd answer your question in two parts very quickly. The first part is that the career civil service attorneys, both on our staff and the General Counsel's Office of the U.S. Department of Energy, made a determination in advising us that, in fact, it was legal for us to subordinate under the circumstances that we were confronted with the Solyndra project. So that is the fundamental decision that was taken. The other thing, the part two of my answer would be quickly that, as I indicated in my oral testimony, and this Congress has heard from another very senior expert, Herb Allison, this tool would only be used in extremist situations where we have a very distressed project. And the important point I tried to emphasize in my oral testimony was that, in fact, by doing it, it's the one last chance we have to, rather than liquidate.
Okay, so this was a
recovery.
This was a distressed project, and you all subordinated in the hope that you could save the project. Is that correct?
That's correct, sir.
I might also say that in the language of the Energy Policy Act of 2005, it also strictly prohibited a subordination in that act itself. What did the lawyer say about that?
The determination, as I just indicated to you, Mr. Chairman, was that we acted perfectly legally within the requirements that were at hand and the law.
But do you feel like that is placing a priority of protecting the taxpayers of the U.S.?
We certainly do. As I indicated in my oral testimony to you, this is a last resort. This is not a tool that's taken lightly.
And how much money has been lost in the Solyndra case?
I don't have the figure right in front of me, but we can get that.
How much money did you all loan to them?
Roughly, it was, I don't remember the exact number, but for the record, I'll give it.
Was it like $538 million, or how much was it?
In that range, sir.
Well, oh, yeah. How much do we expect to recover?
527 was the number.
527. And how much do we expect to recover?
We don't have a determination yet. There's still a possibility. As you know, it is in bankruptcy, so it's being handled by a bank.
But we know the taxpayers will be paid back last, right?
Not necessarily last, but they're not going to. They will be first.
The private investors will be before the taxpayers, correct?
Pardon me?
The private investors will be paid back before the taxpayers.
I don't know the precedent, the order of precedence, but
that's the purpose of subordination.
It is.
Language. On DOE's website, they talk about jobs being created, and they said that Abound Solar would create about or save 1,200 jobs. So many would be created or saved by Solyndra and also by Beacon. And since all of them have not turned out as planned, it looks like a total in this 1705 project has been like 1,174 permanent jobs have been created. A total of loans have been made of $16 billion, which comes to $13,738,075 for every created job. Do you feel like that is a good return for the American taxpayer?
Mr. Chairman, I think you've got to think about that issue in context. From the industries I come from the major energy infrastructure industries. You have to remember that these industries, by definition, are capital intensive, not labor intensive. We have very few manufacturing plants, which are more labor intensive in our portfolio. The predominance of our portfolio and the objective really of the Act is to be creating large infrastructure utility scale projects. and by definition, they are not a multiplier for job creation.
So they're pretty risky, Randy, would you say?
We feel that just the opposite, Mr. Chairman, that solar energy generation projects are just the opposite. They have long-term
Well, let me just say
power
the record
limits to
shows
support.
quite clearly the taxpayers have lost a lot of money. You all have deliberately subordinated them to the private investors, and the jobs created are unbelievably expensive. And that's why we feel like that this program is a total failure. This time I'd recognize the gentlelady from Colorado, Ms. DeGette.
Mr. Chairman, I just ask if you or your staff have this circular A129 that you referred to, if we could put a copy of that into the record, that would be helpful.
Oh, good idea. Yes, we'll do that.
Thank you, Mr. Chairman. Mr. France, I want to ask you a couple questions. First of all, the chairman referred to this circular A129. That circular bans subordination in making the initial loans under this DOE loan program, correct?
I don't have
in the making of the initial loans, not in the restructuring.
that is our interpretation.
Okay.
That clearly the provisions provided to the origination.
The Energy Act of 2005 that the chairman referred to, that also prohibited subordination in the making of the initial loans, not restructuring, correct?
Correct.
And the DOE lawyers looked at this and they decided that it would be legal to subordinate the taxpayers' interests in the restructuring of the Solyndra loan. Is that correct?
Correct.
And can you tell us briefly none of us likes the idea of the taxpayer position being second, to be honest, because in a situation like the Solyndra situation where the company goes bankrupt, then the private lenders have a superior position to the taxpayers, and we don't like that. So I'd like you to explain to the committee very briefly why it was determined in the restructuring of the Solyndra loan that it would be a good idea to subordinate the taxpayers' interest.
Thank you, Ms. DeGette. As I said and indicated in my previous comments, this is a tool of last resort in restructuring, but it is used specifically to attract new, refreshed debt and or equity into the transaction with the hope of saving the project. That's precisely what it's used for. And those investors, new money coming into an already distressed property, will almost demand to mitigate the risk that they have a senior position.
So, in other words, because the Solyndra project was in trouble, it was DOE's hope that they could save this project by restructuring it. Is that right?
Emphatically.
Okay. And it was the determination of the DOE that the only way they could do that, they could attract that new capital, the only way people would invest, private investors would invest, is in fact that if they had the superior position.
In fact,
was that your decision? Yes or no?
Yes.
Okay. And so in the findings, and so it didn't really work out, but we still might recover something. Is that right?
Hopefully.
And one of the reasons why we have these DOE loans is because these are, by nature, risky businesses. Is that right?
Correct.
And for Solyndra, one thing we heard in the subcommittee investigation was that because of changing market conditions, mainly caused by China, Solyndra's business model really had trouble. Is that what DOE found as well?
Absolutely correct.
And that was what caused the whole thing to kind of fall apart. Is that right?
Correct.
Now, in the findings, in the 6 pages of findings in this bill that we're talking about today, one of the findings claims that the DOE loan review process was, quote, driven by politics and ideology and divorced from economic reality. Now, Mr. France, you've been the director of the loan guarantee program since 2007 under the Bush administration, and that's a career position. Is that correct?
Correct.
Now, in your position, do you believe that the statement that I just made from the findings is an accurate statement, that it was driven by politics and ideology?
To the very best of my knowledge, through the whole history of the program, from its inception to today, it has not been driven by any political considerations whatsoever.
Okay.
All of our work and all of the projects are represented by career and due diligence, and they have been awarded on the merits of the transactions themselves.
Now, is it fair to say at the time you approved the loan, You conducted a thorough analysis and believed that the company would be a worthwhile investment for the DOE loan program.
In the time that we did the due diligence, that is absolutely correct, in that time frame.
Can you assure us that the Solyndra decisions were made on the merits and that there was no favoritism shown towards Solyndra or any other loan recipient?
I can absolutely make that assurance.
Now, sitting here today, of course, hindsight's always 20/20. Do you think that there are improvements that could be made to this loan program?
There certainly are, and we are, as I indicated in my testimony, we're employing fundamentally lessons learned all the time throughout the
we would really appreciate it if you wouldn't mind supplementing your testimony today to give this committee some recommendations of what we can do to strengthen the program rather than to just be pounding on it for political reasons.
Well, we certainly will take
Thank you very much, Mr. Chairman.
At this time, I recognize the gentleman from Florida, Mr. Stearns, for 5 minutes.
Thank you, Mr. Chairman. Mr. France, I heard you say in your opening statement that the DOE needs to have the ability to continue, forever almost, to subordinate taxpayers' interest on these loan guarantees. Is that your position this morning?
It is.
Yes or no?
Yes.
Okay. And it is DOE's interpretation that subordination is perfectly legal, in your opinion?
Yes,
okay.
it is.
Let me, Mr. France, read from the Department of Energy Act of 2005 to you on subordination. The obligation shall be subject to the condition that the obligation is not subordinated to other financing. Do you recognize that language?
I do, sir.
Does DOE intend to subordinate other loans? Yes or no?
Mr. Chairman, the question can only be answered in context. And
no, but based upon what your opening statement is, it appears that for other loans that in the future you'll subordinate again.
Your staff has the detailed memo to this effect.
No, but the point is,
we felt that it was, our view and our position is that language pertains to the origination of the transactions, not to projects which are in.
So what you're basically saying is you're interpreting the word is. The meaning and tense of the word is. The obligation is not subordinated to other financing. You're saying is applies only at the beginning and does not later on. So your interpretation of the word is the focus of your interpretation.
As my older son, who is an attorney, constantly reminds me, I do not have a license to practice law.
No, I understand.
So I can only rely on the civil service professional legal staff that is advising.
But your legal staff is making the decision on the word is and the tense being it's okay later on but not in the beginning. Do you intend to continue to subordinate other loans? Just yes or no?
Again, it has to be done in context. It's a tool of last resort on
you need to have this continued ability. That's what your argument is.
Yes, yes, I do. Very, very definitely we do, because if a project is in distress, we want the opportunity to save the project.
Well, if this is true, have you subordinated any other loans? Have you subordinated any other loans?
Not to my knowledge, sir, at all. And we hope not to have to do it. As I emphasize in my comments, it's a tool.
Are there any other loans out there that you're considering?
Not to my knowledge this morning.
Well, you subordinated Solyndra, and how did that work out?
Well, again, in time.
Didn't work out. Now,
I think hindsight is always more valuable than foresight. So
the question was asked, how much money will taxpayers get because of Solyndra? Your answer was you didn't know. Can I tell you what the answer is going to be? They won't get anything more until $75 million of the two hedge funds that you subordinate get theirs first. Isn't that true?
As I expressed, I don't have the details in front of me in terms of the precedent for each of the disbursements.
Now, I don't understand. You work for the administration. They have publicly announced that they don't think taxpayers will get one thin dime back. Haven't you heard their arguments?
Well, but I mean, the final settlement hasn't been done. It's still in investigation and discussion, sir.
Don't you agree that the loan guarantee program has had a tough record?
Quite to the contrary, sir. I think it's been an enormous success.
Okay, we have Solyndra. We have Beacon. The third recipient went bankrupt in 2011. That's true, isn't it?
It is.
Okay, the fifth DOE loan went bankrupt just a few weeks ago. Isn't that true?
We have three
I'm
projects.
asking the questions, please. Isn't that true? The second recipient of a loan guarantee, First Wind, has withdrawn its IPO and has significant debt. The fourth recipient, Nevada Geothermal, was also the recipient of a going concern letter from its auditor. 3 of the first 5 are bankrupt, and the other 2 seem to have significant problems. What do these loan guarantees say about the loan guarantee program's portfolio, based upon what I just told you?
Well, I can give you the numbers, sir.
So you feel they're strong?
The losses on dispersed funds represent 2.59%, and that includes a recovery that we obtained 70 cents on the dollar for the Beacon project.
You feel the future loan guarantees are going to be strong? There'll be no more bankruptcies?
I cannot guarantee that, sir. I think the point is that in this space, there's a high risk in new and innovative, the employment of new and innovative technologies. And that, in fact, was accommodated by the $10 billion that Congress authorized for us for our loan loss reserves.
Mr. Chairman, my time has expired.
Thank you. At this time, I recognize the gentleman from Michigan, Mr. Dingell, for 5 minutes.
Thank you, Mr. Chairman. I would note that in the fall, when we had our earlier hearings, we didn't have the Department of Energy here when we needed them. Today, we need the Department of Treasury, and we don't have them. It's kind of a curious mix. And we do need the Treasury to discuss the questions we're addressing today. I note, just by way of history, that 7 of the leadership on the majority side of the aisle supported the legislation. 17 of my Republican colleagues voted for it, and I did too. I still think it's a good idea. Having said this, I'd like to address this question. Now it is not proper to subordinate U.S. interests to those of other lenders under the legislation in the initial loan or loan guarantee. Is that right?
Correct, sir.
Okay. But you do need the authority to subordinate in the event that the company gets into trouble.
Yes, sir.
Because at that point you have to refinance. And it's pretty hard to refinance and bring in a new investor unless he knows that his money is going to be as safe as it can be. Is that right?
Yes, sir.
All right. Now, so this is an essential tool in avoiding bankruptcy and avoiding seeing the company go under. Isn't that right?
That is always our hope,
It's
sir.
a standard tool that's been used going right back to the beginning of the financial world.
Yes.
All right. Now, so it is not unusual to have then the financing, the new financing, take precedence over financing already in place. That's a standard practice in the financial industry. Is that right?
Yes, sir.
All right. Now, will this legislation then jeopardize future or current DOE loans? And will it make it impossible for there to be a proper restructuring of a loan?
We are of that opinion.
Okay.
Yes, sir.
Now, in your opinion, does the Department of Treasury have the current expertise to review the technology that would be developed under a Section 17 loan?
Congressman, it's not
No,
appropriate.
the answer is that they don't have that authority, that skill, do they?
But
you folks at DOE do, isn't that right?
We have particular expertise, and they do, and they're complementary.
So we need DOE to tell us about the technical questions, and we need the Treasury to tell us about financing.
Yes, sir.
But we don't have the Treasury here. Now, in your time as acting director of the Loan Program Office, have you received any political pressure from the White House to approve a loan your office deemed not qualified for a loan?
No, emphatically no, sir.
You understand the question?
Yes, sir.
And you stand on your answer?
I do, sir.
All right. How many pages of documents has the Department of Energy turned over to this committee?
Thousands, I'm sure, sir. I don't have the number.
Have you rejected the turnover of any documents to this?
To the best of my knowledge, we have tried to fully cooperate with your committee here, sir.
Were the documents turned over on a voluntary basis, or were they subpoenaed?
I can't answer that question. They were voluntary, I'm told.
Thank you. Well, now I note, Mr. Chairman, that we have now the expertise of a witness down there that you called, in which he points out that this sets a bad precedent and that it has the potential for further jeopardizing taxpayer funds. So let me just ask, if one of these companies to which you have a loan guarantee gets in difficulties, if this legislation goes into place, you wouldn't have the capacity to negotiate a restructuring of the entity in such a way as might make it possible to save it. Is that right?
That's my assertion,
Because you
sir.
wouldn't be able to draw additional investors in to help save the public's investment and to keep the jobs and other things that are necessary.
Yes, sir, that's our
All right.
interpretation.
Now, there were some bad decisions, I think, made, and misinformation in the case of Solyndra. But not every application for a DOE loan is like this. And can I ask you this question? Since this big fuss started about Solyndra, have you folks down there at DOE reviewed and corrected the problems that you found with regard to Solyndra? Just yes or no?
Yes, sir.
All right. So the legislation before us today proposes to give new authority to the Treasury Department, but I note we have no witnesses or representatives from the Treasury here. Before we go forward in this, we ought to hear from the people who have the financial expertise of addressing this. Now, I'm a strong proponent of oversight, and I think that we do need oversight. And I would note that as the chairman of both the Energy and Power Committee and Subcommittee and the full committee, and as the chairman of the Oversight Subcommittee, I did an awful lot of investigation. We pulled a lot of folks from both administrations, Republicans and Democrats in, and we pulled the skin off them. But we did a careful job of seeing to it that we got the facts and we got the witnesses that we needed to tell us what was going on. I see none of that happening today, and I think that if the committee really wants to do a good job, we ought to proceed in that direction so that we could be proud of what we're doing rather than having to walk shamefacedly out of here and say, well, we screwed up. I yield back the balance of my time.
Now, I might say, Mr. Dingle, that we did invite witnesses from the Treasury Department, and they respectfully declined to be here.
I've been a member of this committee for a long time. When you invite somebody, they come, and if they don't, you have ways of getting them up here. I was always able, and if the gentleman doesn't know how to do it, I'll be glad to assist him.
Well, maybe we can meet with
For
you
the
as soon as
record.
this meeting's over.
Mr. Chairman, just for the record, we did invite members of the Treasury Department. They couldn't come on the day, which was a couple days after we asked.
Well, the fact is, we did
Yeah.
invite them.
But we could have
So,
scheduled them to come a different day.
this time, recognize the gentleman from Texas, Mr. Barton, for 5 minutes.
Well, I just know I'm glad to be here. And I was invited, and I did accept. This should be a solutions hearing. I don't think anybody on either side of the aisle thinks that the Solyndra loan program, regardless of the political debate, thinks that the Solyndra loan program has been run very efficiently, to be as mild as possible. And the draft bill that Mr. Stearns and Mr. Upton have put out is an attempt to address legitimate concerns about preventing future Solyndras from happening. It's not a perfect bill, and the reason we're having a legislative hearing is because Mr. Upton and Mr. Stearns want to go through the regular order. We can debate the political issues ad infinitum, but at some point we should focus on solutions to protect the American taxpayer in the future. My first question, we have the Deputy Assistant Secretary for Energy Efficiency, Dr. Hogan, but my understanding is you're not here to talk about the Solyndra bill. You're here to comment on Mr. Bass's bill. Is that correct?
That is correct.
Have you been authorized at all to comment on the Solyndra, or you're just here for Mr. Bass's bill?
I believe we have Mr. France here to discuss the loan guarantee program, as that's his area of expertise.
Well, I know Mr. France has been discussing it, but you're a career civil servant. Is that not correct, Mr. France?
Yes.
And you're
Yes, sir.
at least theoretically, you're not supposed to be political. Is that not correct?
That is absolutely
So
correct.
you really don't speak for the Obama administration, do you?
I speak as a civil servant,
As
sir.
a civil servant. And I understand that. My first comment on policy is going to be on subordination. Mr. Dingle and I were on the conference committee when we passed the Energy Policy Act. I was the chairman and he was the ranking member of this committee. And we didn't put a lot of debate into this particular part of the bill, but it was clear that we put the subordination language in to mean exactly what it says. You don't subordinate. There has never, until this loan, been a taxpayer-backed loan that was subordinated. And if I and others on the committee have anything to do with it, there never will be again. When you, Mr. France, say that, well, in extremis you may do it, that's taxpayer money. In the private sector, when you subordinate private sector dollars that are at risk, that investors have put forward. In the public sector, these are taxpayer dollars. You put subordination language in because you do not want to subordinate, period. There's no exceptions. And there's no outside legal opinion that has ever been rendered on this loan that says it's appropriate. You have an email from an attorney at the law firm that's general counsel to the Department of Energy where an attorney in an email says, well, maybe it's okay. You don't have a written legal opinion from an outside counsel that's signed on the letterhead by the senior partner. You do have a DOE general counsel memorandum that's about as tortuous as it's possible to be. So I would hope on a bipartisan basis, one thing we can agree on is that we're not going to allow subordination. And I hope we put some penalty language. One of the reasons you guys got away with it is there's no penalty. There's no penalty. I guarantee you, if you as a loan program officer had been subject to a $50,000 fine, you know, you might have thought twice about agreeing to subordination. So don't insult the common sense of the American people. We knew what we were doing on subordination. We put it in the plain English language, and you violated it. That's wrong, and we ought to be able to stop that. Now, on the general loan program, I happen to agree with what Ms. DeGette said and Mr. Dingle and Mr. Waxman. I don't think we need to throw out the whole program. I think we can clean it up. I think we can make it more transparent. I think we can put some penalties in, put some caps. You know, so I guess since even though you're a career civil servant, you are here for Department of Energy. Does the Department of Energy continue to support that there be a loan program for alternative energy projects? Do you support it or not support it?
We absolutely support.
You do support it. Do you also then support some reforms to make sure Solyndra does not happen again?
To answer that question, we are constantly working on improving the program, Congressman.
So you do support some reforms to the program?
Certainly we do.
Right.
And I offered that in my oral testimony.
I'm sorry, Mr. Chairman, my time's expired, but I yield back.
This time I recognize the gentleman from California, Mr. Waxman, 5 minutes.
Thank you, Mr. Chairman. Mr. France, I want to ask you about the Republican loan guarantee bill. This bill doesn't end the loan program, that loan guarantee program. Under this proposal, billions of dollars in new loan guarantees can be issued in the coming years. But this bill prohibits DOE from considering any new applications for loan guarantees. It freezes those that can be considered by those who came in and applied by the end of 2011. Well, that's an arbitrary decision of picking winners and losers. It creates a winners list, potentially, of a few dozen projects that were submitted before the end of 2011. Those are the only applications DOE can look at. Everyone else, no matter how groundbreaking or promising their technology, loses. This program was created to support innovative energy technologies. That's its whole purpose. But under the Republican bill, new breakthrough technologies need not apply. Is this the right way to structure the program if we want to support innovative energy technologies?
It certainly is not. As I indicated in my oral testimony, Congressman, we feel that it would preclude us from proceeding on new and innovative technologies, particularly in the fossil area, as well as the nuclear and new renewable applications, other than those that we've already received.
I want to understand the practical implications of this bill. If someone develops a new technology this year that dramatically reduces the cost of solar or wind or geothermal power, and they submit a new application, can DOE award them a loan guarantee under this bill?
We could not.
Even the technologies that Republicans claim to support are abandoned. We keep hearing about the importance of innovative coal and nuclear technologies. Mr. France, earlier this week, the committee received testimony from a research administrator at West Virginia University, emphasizing the importance of loan guarantees for advanced coal technologies. Let's say an electric utility submitted a new application for a power plant that utilized a better, cheaper carbon capture technology. Under this bill, could DOE consider that technology for a loan guarantee?
We could not.
And if an application for a small modular nuclear reactor or next generation nuclear plant is submitted, DOE is required to reject it. Is that right?
That's correct, sir.
And instead of considering the new technology, DOE would have to dig through the pile of nuclear reactor applications that were submitted by the end of last year. Is that right?
Correct, sir.
And so the Republican proposal is to prohibit DOE from considering any new applications for new technologies. DOE currently has the authority to issue tens of billions of dollars in loan guarantees for innovative fossil fuel projects, uranium enrichment projects, other nuclear projects, and renewable energy. Is there any public policy reason to think that the applications already submitted are the perfect projects and that there are no new ideas out there that will be worth considering in the years to come?
No, we agree, sir.
This Republican bill, it seems to me, is a terrible idea. It's just the latest Republican assault on clean energy. It provides no answers to our energy challenges. It would stifle innovation instead of boosting it. Now, Mr. Barton made a whole big to-do, very passionate, that we should not allow subordination of these loans. What is he talking about when he talks about subordination?
The subordination question is raised in the context, in our opinion, only and exclusively in projects that are in severe distress, in which we're trying to attract and save the project for the U.S. taxpayer.
So you look at a proposal for a loan guarantee. It looks like it has a lot of promise. It looks like the business is sound enough to succeed, and you give them a loan guarantee, which means if they can't pay their loans, the government's going to pay for their loan. And then they run into financial problems such as their competitors suddenly drop their price. And so even if they come up with this new way of providing this technology, they're not going to be economically viable. Is that the kind of situation we're talking about?
Yes, sir.
And it looks like there's some way they can still succeed, but they need more money. And they go out and find lenders. Is what Mr. Barton is objecting to is the government standing behind those additional loans?
Well, I think again, for the general benefit of the entire committee, Congressman, I think it's an excellent question. The point is that this is a tool that we would employ in the last resort. Even in the negotiations in restructuring, this is not something that we would and do take lightly. It is a tool that is used in extremis, and it is only used after we have failed in negotiations to attract other investments to save the project without using it. It's the last thing we would do.
So it's the last thing you might do to save a project, and if you can't do that and save the project, then the taxpayers have to come up with the money for the loan guarantee.
Yes, sir.
So you either try something out to succeed, or you just let all the losses roll.
In my oral testimony, that was the assertion I made, that you would be hamstringing us and taking a very important critical tool that could in fact save taxpayer money.
Thank you. Thank you.
Gentleman's time has expired. At this time, I recognize the gentleman from Illinois, Mr. Shimkus, for 5 minutes.
Thank you, Mr. Chairman. Mr. France, thank you for your service as a veteran. I appreciate that. And it's very frustrating for me when sometimes I have to agree with Mr. Waxman on some of his points, and I start worrying about my district and what's going on here in the water in Washington. So, but a couple concerns is I did vote for the 2005 Energy and Policy Act, which had this provision, and I side also with Chairman Emeritus Barton in that we just got to be careful of throwing out the baby with the bathwater. But the Congress has changed significantly, and the whole loan guarantee issue with the new federalism and deficits and debts, there's really a debate. Is it the government's role? And if there is, as Mr. Waxman said, a new technology, I'm a big coal guy. There's no current technology for carbon capture and sequestration. I don't believe there ever will be economically feasible. That's the whole climate change debate. But if there was, why wouldn't the private sector return on the investment, assume the risk? And that's this whole debate. Now, I guess the other concern that those of us who haven't spent all the time that the O&I committee has on this stuff, I chair an environment and the economy subcommittee. I do a lot with nuclear waste. I see too many times where I believe the administration, the language of the law is black and white. It's on paper. And so this subordination issue really has us concerned. And to the authors of the legislation, should we, if we don't ever want to subordinate anything else again, should they then adjust the language of the legislation to say if it's a failed norm provision, you really can't subordinate? I mean, that's what you're saying, because you have used, I'm not a lawyer, and I know you shop around and try to find a lawyer that may then give you some impetus to do this, but I think this subordination issue does have traction with the American public. They wonder how it was done with the clear, concise aspects of law. And I'm going to yield my time, but I want to go to Ms. Hogan just 1 second. And part of your statement, you talk about, and this is the vehicle, you talked about electric vehicles and all this stuff. And I just want to make sure that people understand you got electricity is cheaper, but you never, what people have to understand is that to use electric vehicles, you have to generate electricity. And there's varied prices for purchasing electricity per kilowatt hour. From you know, nuclear power being cheap now, coal being cheaper, wind, solar, expensive. So high-cost electric vehicles based upon charging capacities on green power is more expensive than traditional major generation, and you should have that as part of the analysis. Now I yield the remaining time to Mr. Griffith from West Virginia, or from Virginia.
Thank you, Mr. Shimkus. Here's the bottom line. The common language of the land is English. The obligation shall be subject to the condition that the obligation is not subordinate to other financing. Your counsel dances around it and says the word is, makes it only apply for those 5 or 10 minutes during the closing or hour during the closing, and immediately after that, not when the loan is in distress. If you read her opinion, footnote 2 makes it clear that you don't have to be in distress. The Secretary can do it any time. But that's inconsistent with other provisions of the law as well. First, in this particular case with Solyndra, the AG was not notified, as I believe in reading the common English language they should have. But your counsel dances around that too and says that notwithstanding the fact they were in default, it wasn't a payment default, it was another kind of default. And last but not least, when you start looking at what the Secretary's powers are under 1702 G2 and you look at G2B, it says, plain English, the rights of the Secretary with respect to any property acquired pursuant to a guarantee or related agreements shall be superior to the rights of any other person with respect to property. That section makes no sense if you can subordinate any time you want to. And further, I would submit to you that when Solyndra went in default in December of 2010, Secretary Chu testified to this, or to the O&I committee under oath, that he knew in December, he knew in February when this loan was subordinated, that the Chinese could sell their product cheaper than Solyndra could make it. Where were we looking out for the taxpayers of the United States of America? I submit to you we were not. Wouldn't you agree?
Did you want to reply, Mr. Franz?
When we conducted our due diligence, as I've indicated, without being defensive at all, hindsight is always much more valuable than foresight. At my level and the staff level, we were taken completely by surprise. Clearly, in hindsight, the Solyndra transaction was very appropriate in that time, in that place. Given what we now know, we would obviously not have proceeded with the transaction.
Even the subordination? Question mark.
The subordination, again, in context, respectfully, Mr. Congressman, The subordination is a tool that we would use only under extremis. It is not something that we would glibly or cavalierly use at any instant. It is only to save U.S. taxpayers' dollars in the last resort.
Gentleman's time has expired. At this time, I recognize the gentlelady from California, Ms. Capps, for 5 minutes. I'm sorry, I've been told that it should be Ms. Schakowsky of Illinois. For 5 minutes.
Thank you, Mr. Chairman. Mr. France, I wanted to ask you a few questions about the DOE's response to the recommendations of Herb Allison, the independent consultant brought by the White House to review the loan guarantee program. As you know, Mr. Allison's credentials and impartiality are well known. He previously served as the Assistant Secretary of the Treasury for Financial Stability and as the National Finance Campaign Chair for Senator McCain's presidential campaign. He produced a serious report with constructive recommendations. His report, by the way, found that the DOE loan portfolio as a whole was strong and that the program was largely working as planned. But Mr. Allison also suggested that DOE place more emphasis on proactively protecting taxpayer interests and establish a comprehensive early warning system for loans that may be in trouble. So I wanted to ask you, what types of improvements? We've talked a lot and you've said that you've done that, but what types of improvements has the program made in these areas?
Thank you very much, Congresswoman. That's a very good question. I would first at the top of the ledger indicate to you and to the full committee that the Department of Energy is in the process of virtually implementing all of Mr. Allison's recommendations as they might appropriately be done just as quickly as we can. So that's in place. With respect to your specific question, we were very blessed, quite frankly, with a program of attracting Frances Nawachuka from the USXM Bank, who had years of experience in managing their portfolio. She is our Director of Portfolio Management for the program. With her, she imported over systems that were already decades tried and true and proven from the XM experience, as well as those that we obviously operated at OPIC as well, given my background. There's a total watch system that is in place, what we call an oversight, which involves weekly interface with all of our projects and their sponsors. It's now in the process of being fully systematized and will be completed by the end of this fiscal year. There are monthly reports. We have our independent engineers in the field on these projects on a monthly basis. So all of the best practices in the industry are being employed by our program in terms of portfolio management, and all of them were very consistent with Mr. Allison's views and oversight.
So this would include setting very specific benchmarks as well for these kinds of applications?
Yes, ma'am, we do.
Okay. What about the internal management and reporting structures in the loan programs office? Have these changes been made yet?
We are in the process of mating them. They will be completed by September 30th. We will have a state-of-the-art system comparable to all the U.S. governmental agencies by that date. The system is up and running, and we're right now migrating all of the information into this single system of information retrieval.
So you're saying if you came back on September 30th, you would be able to report that all of these systems are now in place and operating?
Yes, ma'am, that is our objective. I hope I will be able to. That is our objective.
Thank you. Mr. Chairman, I think we both agree that the mission of the Loan Programs Office is an important one, and I think that's why the discussion draft before us today does not eliminate the program, I'm happy to say. It's clear to me, however, that this legislation is poorly crafted and has been pointed out in terms of the benefit to the taxpayers as well. And I don't think the legislation before us is a serious attempt, or at least an adequate attempt, to improve the DOE loan guarantee program, which it is my understanding, Mr. France, from your testimony, is in fact implementing the improvements that have been recommended. So we need to do better. Everyone agrees with that, and I hope that we can work on a bipartisan solution to help protect taxpayers and advance the goals that we all share. I yield back.
Thank you. At this time, recognize Mr. Terry for 5 minutes.
Thank you, Mr. Chairman, and Mr. France. As gentleman from California, Mr. Waxman, ranking member, had mentioned when he was discussing the issues with you, that the proposed bill would allow all those that are in the pipeline to go forward, but that the loan program 1705 would cease after that. And that's how you read the bill as well?
Yes, sir. We would not be able to receive new applications other than those.
And Mr. Waxman suggested that that's picking winners and losers. Do you agree with that?
I'm not sure. There might be a non sequitur. My view is that, which everybody I think here acknowledges, we're not clairvoyant enough to know the new technologies that might be right around the corner that would be need.
Do you agree that that's a fair statement, that the bill is picking winners and losers?
It would certainly preclude us from having an open forum for the projects. That's for sure. All we would have are
okay.
If it's picking.
So would it be fairer then, if we're talking about fairness, to just eliminate all of the current ones that are in the pipeline, just to die going further on those?
No.
Because then you're not picking winners and losers.
No, I think the ones that are in the pipeline, as we've indicated, we're in the process of reviewing those that did not make the deadline on September 30th. There are some very
But if there's unfairness to that, and you didn't say to Mr. Waxman there would be any unfairness to not going forward. I mean, he accused us of being unfair.
No, I think the point is, and it's in my oral testimony. I mentioned it. I think we have serious concerns if there is a sunset date of December 31st, 2011, because that will preclude all new implementation of all new technology.
But DOD's authority to issue loan guarantees under 1705 expired after September 30th, 2011.
That's correct.
And there's several that are in the pipeline that were filed before then, and you're going forward, correct?
Yes, sir, and the point is they are 1703.
You were allowed to follow through on those if they had, quote-unquote, commenced construction.
Well, we're not necessarily. These are projects that were 1703 eligible, and there was no sunset date on the 1703
So basically,
program.
then you took some of those programs and switched them from 1705 to 1703.
Yes, sir, as long as they are eligible. And
now,
remember,
but in 1705, in the last 3 weeks before September 11, 2011, there were $10 billion issued to projects. Is that correct?
I don't remember the exact number, but
well, maybe your staff guy that helps you out behind you could help you out.
In all fairness, sir, if you'll permit me, I submitted to your staff when I gave my private testimony, my private interviews, that all of the projects that were concluded under the 1705-2011 deadline experienced due diligence periods. The median was 320 days, 320 working days, every single one of those projects.
Well,
so there was no rush to judgment. We were able to do it in a very deliberate, responsible way.
True or false, DOD approved almost $10 billion in projects in the last 3 weeks of the program.
I don't remember the exact number, but I can assure you that the due diligence reflects the analysis that I provided.
Did all of those... since you're saying, you're not saying yes or no, so it's hard for me to go forward. Did all of the projects that were commenced construction by September 30th, all of those that were funded within the last 3 weeks?
They did, according to our guidelines.
All right. And what is, how does DOE define commenced construction?
I don't have the precise language in front of me, but we can get that for the record for you, sir.
Okay. I would appreciate that. And then of the approximately $10 billion that was authorized in the final weeks before the stimulus deadline, how much has been drawn down? Do you have those numbers?
the actual loans outstanding right now that are active that are 23,353,690,276. I beg your pardon.
Okay.
Yeah, that's it.
Now, that's been drawn down?
Well, let me get that number for you for the record. We can get it pretty quick.
Yeah, I think that would be appropriate. And then what I'm also curious about is if any of the loan guarantee recipients who are not currently drawing funds are any of the those that received in the last 3 weeks, have they missed any deadlines or milestones?
No, not to my knowledge.
All right. My time is...
Thank you. This time I recognize the gentlelady from California, Ms. Capps, for 5 minutes.
Thank you, Mr. Chairman. I'm glad the committee is seeking to advance bipartisan legislation on energy efficiency through one of the topics we're considering today, the Smart Energy Bill. And one of the important advantages of energy efficiency is that it spans all the regions of the country. And regardless of what energy source you support, efficiency is the cheapest, fastest way to address our energy needs. And we know that energy efficiency efforts lead directly to jobs created, which we know also is very important, especially now at a time when the economy is still struggling. The other important aspect of energy efficiency is that these technologies are all readily available. We don't have to wait on some new magic technology. We can take advantage of the existing ones that we know about right away. So there's tremendous potential for this committee to take action on energy efficiency and to help our constituents save money, and that's why I'm pleased with the legislation that's been proposed, and that's really what this is all about. I thank the witnesses, both of you, for your testimony today, and Dr. Hogan, I want to talk with you about improving efficiencies in our homes. I went through a project on my own home, Santa Barbara, California, about a decade ago, and now I've started the process to complete another upgrade. This time I have the advantage of an energy audit of my home, which is part of a county or locally based incentive structure. And it uses a local veteran-owned small business which comes through and then recommends energy-saving projects. I believe there's a tremendous amount of potential with programs designed to encourage homeowners, well, any building owner, to make upgrades. And we actually need to have this done on a regular basis as new technologies that become available. This is countless jobs you can think of. It'll also help to jumpstart a whole industry for home energy retrofits. So, Dr. Hogan, can you describe for us what the department is doing with home energy efficiency? And maybe you can give us a status update on the home energy scoring systems that are now available.
Yes, thank you. So truly there is a tremendous amount of savings that can be delivered to homeowners in their homes through energy efficiency. There's opportunities of 10 to 20% savings on the average home energy bill. Average home energy bill being, for the average home, $2,200 or so. So that's sort of $400 a year that is really out there for almost each and every family in an older home. And so the Department of Energy, the administration, has been very focused on these opportunities for many years. One of the areas we're working very closely with a number of organizations across the country is something called the Better Buildings Neighborhood Program, where we are working to pilot programs that can really take home retrofits to scale. Some of the programs of the past have been slow to get traction in the marketplace because you need a homeowner to want one, and you need the delivery system to be able to come in and provide, high quality audits and then follow through on the projects. So it's because of that we are doing things like the program that you just mentioned, the Home Energy Score. We see that as a great way to bring homeowners information on the efficiency of their home, whether it's highly efficient or very inefficient, and to give them objective, credible information on the low-cost things they can do to improve their home, such as added insulation, home ceiling, the things that are very low cost but can get them a good portion of those energy savings that are there to be gotten. We're also working to pilot that program across the country with 20 or so partners, looking to refine it over the next year and then being able to offer it up much more broadly around the country after that.
Thank you. I just wanted to get in to underscore what you've been describing, and this is a company, but I want to share a story about a company in my district. It's called Gill's Onions. Any kind of onions you eat with your hamburger, next time probably came from this company. They grow, cut, and process a lot of onions. But the company is also known for its technology to produce energy from onion waste. They use that electricity to run their operations. They are totally self-sufficient. This company used some federal grants to design and build this project. They've also partnered with another company, Prudent Energy, to develop a battery system that will allow Gills to store some of the electricity that is extra and use the power in peak hours when electricity costs the most. Gill uses a lot of power for their equipment and their refrigeration. So a project like this makes a lot of sense to them, and it could lessen costs by hundreds of thousands of dollars a year. It's a big deal. And I think it's a good example of local economic development. You can talk about the home use, you can talk about companies using innovation and technology to help them with their bottom line, but also to create jobs, and we can help businesses this way. I've already overused my time. I'll take your nods as that you agree. Thank you.
Thank you, Ms. Capps. This time I recognize the gentleman from Pennsylvania, Mr. Murphy, for 5 minutes.
Thank you. Mr. France, is it your testimony that the loans that closed in September of 2011 have not missed any milestones?
I beg your pardon, Congressman?
Is it your testimony that the loans that closed in September of last year, 2011, have not missed any milestones?
We have milestones. Some of them have that in the manufacturing space, and we're working with them.
Have they missed them? Specifically, AMP. Has AMP missed some of its milestones?
We haven't funded AMP yet.
Okay.
AMP is not even. We haven't even funded that project.
Can you get us a list of all the loans that are pending?
Certainly we can do that, sir. I'll do it for the record.
Do you have any closings scheduled for this year?
None right now, no, sir.
None at all. Okay. You know, I get concerned here because this loan program is one that where I hear folks all over the place talking about subsidies as picking winners and losers. I think there's a difference between doing this right and doing it wrong. You look at countries like France subsidizes nuclear. China seems to support everything massively. And what concerns me a great deal is families in this country have been funding OPEC to the tune of $127 billion trade deficit, where they're building palaces, and we're trying to get by here. There's so many indications that something is wrong, and what really puzzles me is I don't get a sense yet that the loan program at Department of Energy gets it. When I look at all these programs that are failing, Solyndra, the first recipient, went bankrupt. Beacon, the third recipient, went bankrupt. Abound, the fifth DOE loan guarantee, went bankrupt a few weeks ago. First Wind has withdrawn its IPO, has significant debt. Nevada Geothermal, the fourth recipient, has a going concern. And when you look at the things that we have learned over time from these hearings, there were so many signs that Solyndra was having problems. All these federal agencies and departments were saying this is a bad investment. OMB, Treasury, Justice, DOE employees, investors in Solyndra, PricewaterhouseCoopers, Lauren Summers, the President's economic advisor, are all saying this is a problem. And yet, with all those indications, I think what could have been a loan program turned into a White House and Department of Energy earmark program, saying we're going to do this anyways, despite all the signs that no one's going to get paid back, and then ignoring the law about the taxpayers getting paid last. What concerns me here, and the reason why we need to even look at this law, is the Department of Energy is still not admitting problems, still not admitting failures in how the Department of Energy handled this, how they ignored the warnings of failure, continued on, and even when the Secretary of Energy is here, having an attitude which concerns the taxpayers with regard to throwing money down a hole even though you knew that hole had no bottom. If we could make a movie of how the Department of Energy is handling this, of how the Department of Energy would have a typical staff meeting to discuss all these failures and how they handled it, it would look something like this. Would you play the clip, please?
Remain calm. All is well. All is well. Remain.
I yield back.
This time I'd like to recognize the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman, and I enjoyed that movie too, but I don't know if it relates to the Department of Energy, but thank you for my colleague from Pennsylvania. One of the issues I think I have is that, and my colleague mentioned it, we have competition for going to more energy efficiency, whether it be solar or wind power, and I'm frankly successful in my part of the country. In Texas, we're the biggest growing wind power in the country. But unlike some of our competitive countries, if you do what happened with Solyndra, in some of our countries you'd be taken out and shot. We don't do that in our country. We call you before legislative hearings. So I want to welcome you. I joined my colleagues on both sides of the aisle in frustration and anger on the failure of Solyndra, and I participated in oversight hearings before and was on the committee when we wrote the law that created this loan guarantee program. I remember it was under a Republican House and a Republican president. We originally authorized the program. Some of my friends and colleagues on the majority side championed these provisions. In 2005, we worked in a bipartisan manner, and we had our political fights then too, but we worked together and actually legislate. In that spirit, I want to invite both Democrats and Republicans to work to fix this loan program. We can learn from the mistakes that we made and strengthen a program that once enjoyed broad bipartisan support. But I cannot support legislation just as currently drafted. It's a transparent attempt at political messaging and not serious effort to solve the problems that allowed the taxpayers to be on the hook for Solyndra. The bill stands no chance of being taken up by the Senate or even a chance of being signed by the President. Instead, let's not waste this opportunity. We can write a bill that fixes the program. The American people elected us to govern, and on something like this, it's our obligation to find consensus and not create irreconcilable political differences. However, partisan differences can't be solved by our witnesses, and my questions today revolve around solar panel. My goal is to do for solar what we've done in wind in our country. Like I said, in the state of Texas, we've done greatly with wind, and we're going to do with solar if we can find some state money to do it. But Mr. France, I thank you for appearing today. I know the DOE acknowledges some mistakes in the case of Solyndra, and one of the issues that concerned me greatly is the subordination of the loan. When we passed the 2005 energy bill, I remember the language being included saying that taxpayers' interest could not be subordinate to that of any investor. DOE did some legal gymnastics to justify under the law that a restructured loan subordination was permitted. Mr. France, what was the reason to seek outside counsel to draft that subordination memo instead of going to the Department of Justice?
I can't answer your question, sir. That was handled by our Chief Counsel's office and the General Counsel's office of the Department of Energy, sir.
Okay. We want to avoid another situation like that if we had with Solyndra, and I understand DOE believed they were doing their best to save the taxpayers' money by subordinating the loan, but it turns out in retrospect the judgment of the agency was flawed in this regard. It is the current policy of DOE that loan guarantees can be subordinated after restructuring?
That's the position that we've taken. We hope never to have to do it, and as I've indicated in my testimony as well as in questions from the committee, it is a tool of last resort on our attempt to save taxpayers' money from a pure liquidation scenario.
Well, learning what we've learned from Solyndra, does restructuring seem like a risky bet now?
I guess I don't understand your question.
Well, you know, we're talking about $500 million, and obviously we threw good money after bad. And it seems like somebody ought to say, hey, that was a bad decision we made.
The decision that we took, Congressman, again, was in the time, at that time, and in that place. Hindsight is always more valuable than foresight. for sure, and it was a very appropriate transaction at the time. Obviously, we would not do it again, knowing the circumstances we do, particularly in the marketplace.
Well, my concern is that the 05 energy bill that put in there that you couldn't subordinate, and there was efforts to do that by getting some great drafted letters, and I practice law too, and but you get 3 lawyers, I can get you 4 opinions depending on how much you want to pay. But I think this committee ought to work in making sure that subordination is not allowed, and that I thought that's what the 05 energy bill did, but obviously it didn't, and so that's what I would hope our legislation would be, that we make sure that the taxpayers' dollars always come first before the private investors. Mr. Chairman, I know I'm almost out of time, and thank you for the time.
Thank you very much. At this time, I recognize the gentleman from Texas, Dr. Burgess, for 5 minutes.
I thank the chairman for the recognition. Mr. France, let's stay on the subordination issue. The Energy Policy Act of 2005, I'm sure you're familiar with it because you were one of the original hires in that Loan Project Office in 2007 to administer this program. In 1703, the clause under subordination reads, "The obligation shall be subject to the condition that the obligation is not subordinate to other financing." Simple, straightforward statement. Even a non-lawyer like myself can understand it. The difficulty that, and I think Mr. Green is exactly right, his line of questioning is exactly correct, but the difficulty is then the law does not go on to prescribe any penalties, civil or criminal, for violation of this. So while I believe the Secretary to have been in technical violation of this passage of the Energy Policy Act of 2005, there is no penalty. So for that reason, earlier this year, I introduced another bill, 5863, to prescribe civil monetary penalties between $10,000 and $50,000 for people who violated this statute. The bill is based on the Anti-Deficiency Act and provides civil and administrative penalties for executive branch officials who violate appropriations bills, and has over a century of precedent. And I honestly believe this may be a better way to get at this problem. Now, you reference that, well, actually, Secretary Chu came to our committee, and he referenced other committees that were on the watch list. Can you provide us with a list of those companies? Companies who are on the watch list? Can you provide? I don't expect you to have it at your immediate disposal, but will you provide that to the committee?
Well, let me take that question for the record, and we'll endeavor to be responsive, sir.
Well, and the reason I want you to be responsive, the reason why it's important, because, I mean, the whole purpose of this hearing is no more Solyndras. Maybe it should be no more loan subordination. Are we at risk for the department to have to look at subordinating a loan as a last-ditch effort to save taxpayer dollars, as you've described? I want to help you here. You keep talking about hindsight is perfect. I want to sharpen your foresight so that we can anticipate the next loan subordination activity and either have it not happen, or if it does happen, make sure we follow the letter of the law, or if we don't, that people understand that there are penalties for not following the letter of the law. Now, also on the issue of hindsight or foresight or wherever site we're on right now, I've heard several people talk about the fact that it was the Chinese that actually sandbagged Solyndra. They dumped a bunch of stuff on the market. Do you recall that as being part of the discussion?
Well, I mean, factually, it is a part of the discussion.
No, factually, 4 days prior to the closing of the loan, there's an email from the Energy Branch Chief at Office of Management of the Budget. This is tab 7 in your evidence binder. There's an email from the Energy Branch Chief at Office of Management of the Budget to his immediate superior that describes the problems. He wants them to slow down. He says, you're going too fast. You're not following the rules. And then referencing at the bottom of the email, Chinese solar firm revises price. As prices slump, solar industry suffers. More sun for less. Solar panels drop in price because of Chinese imports. This was known. This was not a surprise. This was not new information. Your own Office of Management of the Budget was saying, we need to slow this thing down and follow the rules. But instead, it was speeded up for reasons that this committee, to the best of my knowledge, still has not been able to discern. And that's really where this whole investigation has hinged. The administration would have done itself a favor to get out in front and be honest with the committee. If this is a mistake, and we accept the fact that people make mistakes, and then we can improve our policy from recognizing those mistakes. A big mistake was made here, and then you papered over it. You glossed over it and went ahead. Do you have any comment about that?
I don't. I haven't looked at that.
Well, you have the evidence binder in front of you?
I do not, sir.
Where is? All right, we'll get it for you. I'd like for you to look at that while you're still here. If I could, Dr. Hogan, I just have one question on the energy efficiency. You spoke a lot in your testimony about electric cars. And in fact, it was kind of interesting on the last Energy and Water Appropriations Bill, there was an amendment from a representative from California who wanted, she said people suffered from range anxieties in their electric cars, and she wanted to help them with that. I don't know what you do short of a 300-mile extension cord, but you know, there are other technologies, and this whole concept of picking winners and losers, down in my neck of the woods, T. Boone Pickens talks a lot about using natural gas to power especially the big rigs on the road. Why would we pick electric car technology when there are competing technologies that other people are investigating? Why pick a winner over a loser in this instance?
First, as I said in my testimony, the Department of Energy has a full portfolio of R&D in the vehicle space. We are interested in natural gas and would enjoy having a conversation with you on that. But as you look at the different vehicles that are out there, the different vehicles we use in our economy, from light duty to heavy duty, it does seem that different technologies have sweet spots in different areas.
And I recognize my time has expired, but the difficulty that you have is consumers don't want what you're trying to make. And we'd be far better served if we let the market absorb the appropriate signals and respond rather than us trying to force an issue on the American people. Mr. Chairman, in the interest of time, I'll yield back. I know we have a vote pending.
Thank you. Anyone on your side? Okay. Who do we have over here? This time I recognize the gentleman from Georgia, Dr. Gingrey, for 5 minutes.
Mr. Chairman, thank you. Mr. France, I know it seems like we've beat this horse to death, but I don't think quite so. So I want to go back to this issue of subordination, particularly in light of the fact that you have said repeatedly before this committee this morning that you believe that under this loan program you have the authority to subordinate in an extreme situation. You have said that a number of times, and I'll be happy to have you either refute that or confirm it. But here is the situation. In the private sector, if a loan were to be subordinated, and it's a scenario that you described that the borrower is about to default, to declare bankruptcy or whatever, and the person that made the original loan, that's in the first position, is going to likely lose all their money because of the bankruptcy that is likely to occur. And a deal could be structured. Maybe the original lender has no more money or is unwilling to put up any more money, throw good money after bad, as the expression goes, and somebody else, though, is willing to do that, maybe because they get a higher rate of interest to come in and pony up some more money. You might be able to restructure a deal like that, but I would think, now you've got a legal team behind you of young, bright-looking people, and you've been in business yourself a long time and maybe done some of these deals, you would have to go to that lender that's in the first position and get their approval before you could restructure and subordinate them to a secondary position. Would you not?
You do. You're in consultation with them, as we were.
You were not in consultation with me. I'm a taxpayer. You were not in consultation with we, the taxpayer. That is the problem here, and that's the thing that just amazes me that you don't seem to get. Now, there was a memo that our committee obtained that Jacob Lew, the former director of OMB, sent not only to the Department of Energy, but as I understand, to every other agency and department of the federal government, very specifically saying, it was Circular A-129 to be exact, this guidance document that was sent by then Director of OMB, Jacob Lew, to heads of executive departments. You cannot do this. Under these loan programs, whether they're Department of Energy, Department of Agriculture, or wherever throughout the federal government. This cannot be done. And you guys were told repeatedly, consult with the Treasury. After all, it was in the Department of Treasury where the money was being lent. And you repeatedly refused to go to the source of the funding to ask the question if this was okay. You just, as my colleagues have pointed out, asked some rookie junior counsel in the Department of Energy to give you a quick and dirty opinion so you could go ahead and get this done and get it out the door. And that's where you, and I say you, and I use that term, Mr. France, generically. I think you've been a good witness. I think you've been honest with us. But I think you are honestly wrong in thinking that you could continue in this loan program. And I'm like some of my colleagues on both sides of the aisle. I'm not ready to say that we should throw the baby out with the bathwater and just eliminate the loan programs entirely. I want to think very long and hard on that before I would vote to do that. But if you're telling me that if we continue the loan program and you're the guy there, you're the straw that stirs the drink in regard to this loan program, and another extreme situation comes up, in your judgment, you would subordinate the taxpayer. If that's the case, then I would say, let's get rid of the damn thing. I don't think you have the authority to do that. And if you know, I want you to respond to me, and if you're unclear about it, you get together with your team and y'all better look at the documents and study this long and hard, because I think you're flat wrong on this.
Well, my only response, and at the expense of just the reiteration of my comment, we would hope to never have to subordinate. It is a tool of the last resort. I have more experience in the private sector, quite frankly.
Let me interrupt you just for let me interrupt you for just a second, because you're going down the same path. It is not a tool of last resort in your quiver, in your toolbox. You don't have that tool. Don't you understand that?
The advice, and I again do not have a license to practice law, so I have to depend on the civil service advice of our general counsels, who reached a different conclusion, sir.
Well, I suggest that you go back with your counsel, and I suggest that you talk with the attorneys and the bankers in the Department of Treasury, and maybe even you know, a little sidebar with Jacob Lew himself, and look very carefully at Circular A-129, because Mr. Chairman, I apologize to my colleagues for, as I say, going back to this issue over and over again, but the gentleman just doesn't seem to get it. And that's the reason why I think we just need to make sure that he does get it. And with that, I'll yield back.
Thank you. At this time, I recognize the gentleman from Kansas, Mr. Pompeo, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. France, for being here today. I've heard two different, we've got this bill. I think it's a good bill, trying to make sure that we don't have anything like Solyndra. I've heard two different descriptions of the problem. Mr. France, you cite the problem as inadequate foresight, not enough data. If you had to do again, you'd do it differently. You might not make the loan, you might not do the subordination. That's one identification of the problem. A second one I've heard from folks on both sides here today is we just need a few more processes and procedures, and gosh, we won't ever end up here today. I think those are both wrong. The government's got no business having either the Section 1705 or Section 1703 program in the first instance. The very problem, Mr. France, and you're stuck here testifying today, is it's inevitable that there'll be loans go bad. It's absolutely, I came from the private sector, it's absolutely inevitable. That's why the government shouldn't be in this business in the first instance, because we will always want to second guess. We'll always, and then when we find things like this subordination and we find emails talking about hurry and get a loan out the door because there's going to be a press conference where the president or the vice president wants to go, the government subjects itself to this kind of inquiry, and when we don't get documents, I think we have every right, indeed an obligation, to pursue that line of inquiry. So I'm going to get you out of this. I'm going to get you out of this completely. You don't ever have to come testify about a failed loan again. We'll eliminate the program in its entirety, and so I would love to see us do that. I want to talk to you about, we've got a provision that does let some folks continue in the 1703 program, those folks that have already filed applications. If we went further and said you couldn't disperse any funds even to those people, tell me what that would do to you in the loan program office.
Well, I think, Congressman, the point is that the program was established as a bipartisan program to bring new and innovative technologies that also reduce, sequester greenhouse gases and pollutants. This, having spent my whole career in the energy infrastructure industries, this is high-risk business. The other point I'd like to make for the benefit of the entire committee is that this involves what we call discretionary capital expenditures. Major corporations don't have to do this. What has happened, though, the success of this program is that we have brought small investors as well as large investors forward to take very high-risk decisions in employing and bringing new and innovative technologies to the marketplace. We have done it very successfully, and otherwise that would not have happened.
Yeah, but
I know
you
you've had a lot of testimony here that other nations.
I don't want to debate the policy. You're not going to convince me. I have more confidence in the private sector. You have more confidence in government. I understand that distinction. I asked you a specific question. If we denied any further guarantees from being made, even those folks who had provided applications to you so far, tell me what that would do to the loan program.
Well, we have a group of projects which I've indicated, which are 1703 qualified, that did not make the sunset deadline of September 30th, 2011. And within that cadre of projects, there are new and innovative technologies that we want to bring to the commercialization.
How much money have these companies expended in doing? I'm concerned about the private entities that have already put money in at risk and relied on what I think is a terrible government policy, but nonetheless have relied on. I don't want to do any. I'm trying to avoid doing harm to them in this transition to what I think the new world ought to look like. And so that's my question. Can you tell me what the impact is for those?
I'll have to do it for the record, sir. I don't have those numbers right in front of me, but we'll follow up with you, sir.
Great, thank you. With that, I yield back the balance of my time.
Gentleman yields back the balance of his time. This time, I recognize for 5 minutes the gentleman from Colorado, Mr. Gardner.
Thank you, Mr. Chairman. I appreciate your time, and to Mr. France and Ms. Hogan, thank you very much for being here today. Just a couple of quick questions for you. When it comes to solar projects, how many loan applications do you have in this program, or not applications, excuse me? How many active participants, remind me, are in the program right now?
Well, I think I have the schedule right in front of me. We have, in solar generation, there are 12 projects. In solar manufacturing, we have 4 projects, but only 2 of those 4 have been dispersed or we have gone forward with. 2 are on hold for the reasons that have been identified here in this hearing today. So those are the major. So it's essentially 12 plus 4 for 16.
Okay, so you've got 16. Does that include Solyndra or Abound?
It does, sir.
It does, so that number does include that.
Yes, sir.
You set a number of benchmarks and milestones.
Yes, sir.
And so are those just major milestones, or are you actually monitoring compliance with the terms of the contract itself?
We're doing both, as a matter of fact.
So you're making sure they're complying with every term of their contract?
Yes, sir, we are, on a weekly to monthly basis on every project. Now, there's a reasonableness, and that is that if you're going, what we've done now going forward, we're putting phased disbursements against absolute hard milestones, and we will cease dispersing if, in fact, they're not meeting their milestones.
Okay, but in terms of the contract, are all 12, 14, however, in existence today, are they meeting every term of their contract?
To the best of our knowledge. No, don't confuse the milestones with defaults. They're not in default. The only ones that are in default are the ones that you have identified, the committee's identified.
But if they're not complying with the term of the contract, are they in technical default?
No, they're not in we're working with them if we can, to permit them time to make a correction. I mean, for example, a perfect example, you're familiar with, if there's a turbine that has some blades that aren't working, but it's known that it can, if there's a fix that's delaying, it might delay the schedule.
What about the terms of the contract? Every single one of these are complying with the terms of their contract to the T?
To the best of our knowledge. I mean, we're as I said, we're monitoring them on a weekly basis.
All of them are paying Davis-Bacon wages as required?
to the best of my knowledge, I don't know of any that aren't.
Was Solyndra or Bound paying Davis-Bacon wages?
I'd have to take that question for the record. I don't have that information right in front of me.
The loan was closed for Abound 10 months before funding was cut off. What changed in those 10 months?
The marketplace was the deciding factor.
10 months, you didn't know that it would happen. You didn't see it coming.
We didn't until after we had closed.
I'll just switch to questioning of Ms. Hogan. Ms. Hogan, talking about energy savings performance contracts, I helped lead a letter to the President. Over 20 Republicans signed this letter, actually commending the President for his work on $2 billion worth of investments in energy savings performance contracts, making sure that we encourage those projects to actually go forward and happen. But there have actually been 55,000 potential energy conservation measures that have been identified. Can you tell me where we are in reaching those? Where are we in terms of reaching? There's 55,000 potential energy conservation measures agencies that have identified.
Right.
Can you tell me what we're doing to advance these measures? I mean, where are we on?
Yeah, so certainly the FEMP program is working with all the agencies around the energy conservation measures that they have identified. Certainly one cannot fund all of the measures just because they have been identified. So one of the big conversations is where does the funding come from and what appropriations that agencies have to put toward that, as well as what use we can have of the energy performance contracting.
And of course, with energy performance contracting, you don't need to have funding because it's all done through the private sector.
Correct. So with the energy performance contracting, our big effort right now is to help the federal agencies be successful with the President's challenge for the $2 billion by December 2013.
But we know that in 2011, energy savings performance contract project investment was $253 million. But that's the lowest level actually since 2007. Can you talk a little bit more about why we're not actually encouraging more energy savings performance contracts to actually get to the $2 billion?
So we are encouraging them as aggressively as we can. The President's challenge to the federal agencies has been a great way to get everyone focused on what performance contracting can do. And we've got a tracking system in place where each of the agencies is being measured toward their piece of the commitment to the President's goal with sort of monthly tracking to see where they are. And we are right now on track to get there. So we're feeling pretty good about that.
Thank you, Ms. Hogan. Mr. Chairman, I yield back my time.
This time I recognize the gentleman from Louisiana, Mr. Scalise, for 5 minutes.
Thank you, Mr. Chairman. I appreciate you having this hearing. I know we've been looking into Solyndra and the entire loan program for a long time now. Our committee, I think, has done tremendous work in uncovering not only this scandal related to Solyndra, but a lot of the flaws in the loan program. I want to ask Mr. France, when we had, you've had some conversations with other members about subordination in general. Where in the law is it that you feel that you have the authority to subordinate taxpayers?
Again, Congressman, I have to defer to the opinions of the civil servants and the General Counsel's Office of the Department of Energy and our Chief Counsel. I do not have a practice.
Well, and you're hiding behind civil service, but it's my understanding, and I'm not sure how much you've reviewed a lot of the documents that we've reviewed on this loan program, and especially as it relates to Solyndra. But going back to prior to the decision to subordinate the taxpayer, we uncovered some communications, it seems like, with an outside law firm that Department of Energy was having on subordination, whether or not it was legal. And it was our understanding that there was a draft of a legal opinion from outside law counsel that it would not be legal to subordinate the taxpayer. And at that point, the department pulled back and said, no, we're just going to go find somebody in-house to give us the opinion we wanted. And that's where this memo came from. Are you familiar with that
no,
whole
with all due respect, I can't really comment on your questions.
Are you disputing that any of that happened?
I'm sorry?
We've seen some of that information. Are you disputing that there was outside counsel being talked to about subordination?
I'm not disputing it one way or the other, sir. I'm just not familiar with those communications.
Well, let me ask you, because we've talked about some of these other problems, and many of us have disputed whether or not you even have the legal authority to subordinate. You're saying here today that you still think you do have the legal authority to subordinate. Again, if you could show me in the law where you have it, that's one thing, but you're hiding behind some kind of legal opinion that comes from in-house counsel, even though what we've seen is outside counsel was getting ready to tell you you don't have the legal opinion. So then you went and, I guess, forum shopped. I mean, that's forum shopping in the Department of Energy. But even within the Obama administration, we've got emails from the Department of Treasury telling Department of Energy that we don't think it's legal for you to do this. You ought to go talk to the Justice Department. Did you see those emails?
No, I did not, sir.
Now, I don't understand how you can sit here and tell us you're serious about reforming this loan program. You told Mr. Barton, you said, we're looking at ways to reform this. We don't want to make the mistakes of the past. You don't even know what happened. We had committee hearings. I mean, this stuff that was broadcast on C-SPAN. You can go find all this. We had to subpoena some of these documents, and you're telling us today you didn't even go look at this, and yet you're serious about reforming a program when you didn't even go and review the record that's been out there for months and months of what we've uncovered in this investigation. There's stuff that's out there in the public domain you can read in the newspaper about the problems leading up to this subordination, and yet you're telling us you don't even know what happened. You don't even know this history, but you're serious about reforming the program. You don't even know how it got to this point?
I'm familiar with what we did and how we did it. I'm not familiar with the background information.
But the background is part of what got us to this point, what got the taxpayers to having lost $535 million of money. It wasn't just us here in Congress on this committee saying it shouldn't have been done. You had people within other agencies in the Obama administration saying you shouldn't do it. And it's their emails saying this. And you're telling me you haven't even read those emails?
No, I have not, sir.
Well, you better go back and read them. I mean, it's part of your job, if you're going to reform the loan program, to know how we lost $535 million of taxpayer money. Because there are other loans out there. You're admitting how many more billions of dollars in taxpayer money are out there at risk in these loans?
As I've indicated to you and to the full committee, this is a high-risk business.
That's a question. How much money? How many billions of dollars are at risk in these loans?
I don't have that. I'm not
How can you not have that? You're in charge of the
clairvoyant.
program.
Just not particularly clairvoyant enough to know what the future holds. We're working
No, how much
very hard.
money is, how much taxpayer money is invested right now in these loans?
Well,
I would think you'd be able to give me an answer. You run the program.
yeah, I can tell you under the 1705 program, $16.1 billion is
So there's $16.1 billion of taxpayer money at risk. This isn't venture capital money. Private sector people thinking this is a good bet. Obviously, they turned their back on it. Private sector said, we probably don't think these investments are good enough, so we're not going to invest in them. So these companies went to the taxpayer. They went to your agency, and they got taxpayer money. And so you're now the steward of that taxpayer money. I would hope you would go back and look at the history of how we've lost hundreds of millions of dollars of taxpayer money, because there's still billions out there. I mean, do you understand why it's important that you know this history?
Sure, certainly I do.
Well, then I just find it perplexing that you're going to sit here and tell me you haven't looked at it yet. Because we've had hearings on this stuff. We've got members on both Republican and Democratic side that have read this. I mean, some people fought us subpoenaing the information, but we passed it anyway. We got the subpoenas. We got the documents. We know what the emails say. And many of those emails said, don't do it. And yet you're sitting here still saying you're going to do it. You'd subordinate the taxpayer, even though they're emails from Department of Treasury.
With all due
saying
respect,
don't do it.
Congressman, this is a tool of the last resort. We hope to never have to use it again.
But you said you're still willing to use it, didn't you?
Until the attorneys advise me that it's a tool that we can't.
Which attorneys? Some attorneys were going to advise you not to do it, and so you went and found other attorneys. I mean, please go look at the history. It's your job to look at this history, because there's billions of taxpayer money still at risk, not to mention what was already lost with Solyndra, Beacon, and maybe others.
Gentleman's time has expired.
We don't apparently have a document notebook for this hearing, and I would just request that Mr. Skilly place the documents he's referring to, the outside counsel opinions, saying that the subordination was illegal, into the record, so we could know what he's talking about.
We've got many documents in the record,
If you
thousands.
that would be helpful. Thank you.
We'd be happy to continue to go down this road and
All
try
of
to
these
find out more
documents
information.
have been in the record of prior hearings of oversight investigation. We'd be happy to put them in the record of this hearing. This time I'd like to recognize the gentleman from California, Mr. Bill Bray, for 5 minutes.
Mr. Ms. Hogan, would you clarify something? We talk about electrification, both for transportation and for generation, and both of them in the most efficient form need a quantity of rare earth to be the most efficient out there. My question is, when you guys are talking about this, how much discussion do you have with the Interior Department about if we want to go to electrification, if we want more wind generation, if we want to produce this domestically, we've got to have, or we should have, domestic sources of essential components of this. How much interrelationship or communication do you have with the Interior Department about opening up public lands for mining of these rare earths or other components that are essential? What's 70 pounds of rare earths in a Prius? Is there any discussion at all about assuring their sources for the raw materials there to be able to produce these strategies, things like electrification?
Yeah, so we're dealing with the rare earth issue in a number of ways. And that includes having put together a strategy on rare earth materials so that we can actually understand the criticality of them and the things that we need to do. We are engaged broadly across the federal government in what the opportunities are to sort of assure those supplies.
You're aware that China is already using the rare earth strangle on Japan for their foreign policy stuff based on the fishing. Okay, let me go right to the thing. We all agree that conservation overwhelmingly tends to be the most cost-effective way of saving energy and saving money, right? We require mileage efficiency out of our cars, don't we? Do we require under our transportation funds energy efficiency out of our roads? University of Texas, University of Missouri, shown studies that inappropriate traffic control can be adding as much to 22%. And I know I sound like a broken record on this, but when we point fingers at the local businesses and we point fingers at consumers and say they must change the way they do business, how can we walk away from one of the largest opportunities we have to reduce fuel consumption and pollution when, is it just because it's government, so we just don't hold government to that standard?
I believe what you're referring to are other strategies you can use to address transportation, dealing with vehicles miles traveled, dealing with congestion issues. Again, that is an area where the Department of Energy is actively engaged with the Department of Transportation and others and addresses those issues through sort of a clean city.
What kind of outreach do we do to local governments, county, the League of California Cities or the counties? Things like a stop sign is 5 times more polluting than not having one. Why are we continuing to not only allow, but pay for local government putting up 4-way stops or putting up instead of yields or not synchronizing traffic signals or not using more roundabouts, which are one of the most efficient? Why aren't we as aggressive with our local government and our county, our state government, as we are with our auto manufacturers with our CAFE standards?
Well, certainly we can have a conversation about what the role of the federal government is in this space. What we have been doing very actively for a number of years is working with our states and our local governments to bring forth the best practices to actually show them what the benefits are with these various strategies so that they can adopt them. And that is having a fair amount of effectiveness.
Okay, I'll just tell you because I come from the local side. But I'll tell you, we have spent decades talking about fuel efficiency in the cars. And I would challenge that this committee has held more than a few hours or even a few minutes discussing about how to require traffic management to be modified to be the more efficient. And that, when you talk about studies showing as much as 20% of mobile sources, this is a big deal that I think our credibility is destroyed if we say we're going to do this to the private sector, but if it's the public sector creating the problem, we're just going to overlook it. You know what it looks like? It looks like rather than being pro-environment and pro-conservation, we're anti-private sector. I think that we can gain a lot of credibility by being as tough on our fellow government agencies as we are on the private sector. And I'll harp on one thing. I've been on Dan Lundgren and the local about the fact that we can't even allow a blinking amber light next to this building because it's just so much easier just to have a blinking red light. And it's just, why bother? Because every one of those blinking red lights forces consumers to burn more fuel and pollute more, but we stand by and don't bother because it just seems too small to bother with. And I think when we talk of up to 22%, don't you agree? It's something that we need to go revisit and should be more aggressive on.
I think we should always look at those types of opportunities and figure out how to share the best strategies that can get those types of savings, and we'd be glad to have a conversation with you on that.
I appreciate it, Mr. Chairman. I'll just say the ranking member, you remember in the 70s, people said that cars have to be big and heavy to be safe. They have to be polluting to be safe. And you find people will use, government will use the same argument that we have to have stop signs everywhere, we have to do this, we have to stop traffic. I think it's time that we put the pressure on our mayors and our county supervisors and our state officials, just like we put on our automobile manufacturers. And that's something both sides ought to be able to work on.
Mr. Bilber, I'll just say in the 1970s, that's when I got my driver's license. I was just glad to have a car.
Yeah.
Yeah, we look forward to working with you on that. We have votes on the House floor, and I understand we have like 7 votes. And so we're going to dismiss the first panel. Mr. France, Dr. Hogan, want to thank you for taking time to be with us this morning. We appreciate your testimony, and we look forward to working with you as we move forward. Those members, those panelists on the second and third panels, I do apologize in advance for this delay. We're going to make every effort to be back here within 1 hour. Which would give everyone the opportunity maybe to go have a wonderful meal at the cafeteria. And then you can all come back refreshed, and we'll meet you back here, hopefully at 15 to 1. So the committee is in recess until then. Thank you. All right, so I guess Cliff.
Ellen emailed you the votes.
Oh, she did? Okay.
Committee will go ahead and reconvene. Other members very likely to be making their way back from the House floor, but we do have 2 panels left to go through on this Subcommittee on Energy and Power and Subcommittee of Oversight and Investigations joint subcommittee hearing. And for our second panel this afternoon, we're very fortunate to be joined by Dr. David Kreutzer, who's a research fellow in energy economics and climate change from the Heritage Foundation, Ms. Diana Fushat-Roth, I didn't get your name right, Furshgott-Roth, is that close enough? Senior fellow from the Manhattan Institute for Policy Research, and Mr. Kenneth Berlin, General Counsel and Senior Vice President for Policy and Programming, the Coalition for Green Capital. We will recognize each of you for 5 minutes for an opening statement, and although we will not interrupt, I do ask that you pay attention to the little black box in front Dr. Kreutzer, you're recognized for 5 minutes for the purposes of an opening statement.
Thank you very much, members of the committee, for giving me this opportunity to discuss loan guarantees. My name is David Kreutzer. I am Research Fellow in Energy Economics and Climate Change at the Heritage Foundation. However, the views I express are my own and should not be construed as representing any official position of the Heritage Foundation. Today, I would like to address several aspects of loan guarantees and investment in energy markets. My first point is that private capital markets will fund risky projects, projects that involve large amounts of capital, and projects that take a long time to repay their investors. These features are not characteristics of market failure, nor do they justify subsidies, loan guarantees, or mandates. 10-year-old Christmas trees and 20-year-old whiskey are both funded by private investment, as is the development of new drugs, which can take decades and which can cost billions of dollars. My second point is that the Section 1705 loan program was founded on a flawed concept. The concept being that the Department of Energy can systematically discover projects that are both commercially viable and unable to attract sufficient private investment. The definition of commercially viable has to mean that the expected returns exceed the expected costs in present value sense, the sense that matters to financial markets. The implication is that the Department of Energy can consistently uncover profitable investments that profit-seeking investors have missed. Third, loan guarantees can misallocate capital even when the loans are repaid. The projects that can use funding in the economy are many times greater than the resources available to fund them. So the projects must be sorted and ranked. This is just what financial markets do. Projects with higher expected rates of return get funded before those with lower rates of return. In my written testimony, I describe a project that was sold by the initial developer hours after receiving a 1705 loan guarantee. I estimated that the value of the loan guarantee was about $100 million, and that with this valuable guarantee as part of the package, the project sold for only $75 million. This implies that without the loan guarantee, the project had a negative return. That is, the inputs had a higher value than would the energy that these projects were going to produce. My fourth point, the 1705 loan program is likely to fund two sorts of projects: ones that are not commercially viable, or on the other hand, ones that should have been financed privately. Of the 26 projects listed on the Department of Energy's website as having received 1705 loan guarantees, 3 have gone bankrupt already. They are Solyndras, Beacon Power, and Abound Solar. A fourth company, Nevada Geothermal, appears to be struggling, its stock price having dropped 90% since the fall of 2010. In the category of firms who should have had the resources and financial sophistication to fund their own projects are the Caithness Shepherd's Flat project, one of whose partners is General Electric, a company whose market capitalization is $170 billion. Nevertheless, this project received a loan guarantee for $1.3 billion. Cogentrix of Alamosa, which received a loan guarantee of $90.6 million. Cogentrix is a subsidiary of Goldman Sachs. It seems incredible that Goldman Sachs, one of the world's most sophisticated and active financial firms, with a market capitalization of $47 billion and one that handled $529 billion of mergers and acquisitions in 2011, could have a commercially viable project for which they could not get funding. Exelon, with a market capitalization of $32 billion, received a loan guarantee of $646 million. Granite Reliable received a loan guarantee of $168.9 million. Granite is 75% owned by Brookfield Asset Management, which has a market cap of $20.5 billion. Mesquite Solar One received a loan guarantee of $337 million. Yet Mesquite is owned by a subsidiary of Sempra Energy, whose market cap is $16.5 billion. NextEra Energy Resources received a loan guarantee of $2.3 billion, while they have a market cap of $20 billion. NRG received loan guarantees of $3.8 billion for 3 projects. NRG has a market cap of $3.9 billion. However, one of NRG's projects has partners whose parent companies are BP, Chevron, and State Oil. Those 3 companies alone have a market capitalization that's close to $500 billion. Nevertheless, they received a loan guarantee. Prologis, a real estate trust with a market cap of $15.2 billion, received a loan guarantee of $1.4 billion. In conclusion, private markets fund risky, large, and long-term projects. Pretending that loan guarantees are necessary for commercially viable projects leads to either failure or unwarranted taxpayer-funded subsidies. Firms with tens and hundreds of billions of dollars don't need federal loan guarantees. Thank you.
Yes, you're welcome. Your opening statement.
Thank you very much, Mr. Chairman. I'd like to introduce the interns who are here with me today who have, some of them, it's their first trip to Capitol Hill. I have Christopher Bien, Leah Leversky, Chi Tsong, Chris Munger, and my son Theodore Furchgott. They're very privileged to be here at the hearing.
Well, welcome, welcome. Nice to have you.
Solyndras' bankruptcy has been attributed to factors beyond its control, such as the falling prices for polysilicon products and lower costs of pricing in China. The documents filed by Solyndra with the Securities and Exchange Commission in September 2009, after Vice President Biden visited the premises and ahead of an initial public offering that failed in June 2010, show that the company was fully aware of its risks. PricewaterhouseCoopers, Solyndra's auditors, expressed public concern about the company. Reuters reported, quote, PricewaterhouseCoopers LLP said Solyndra's recurring operating losses, negative cash flows, $532 million stockholder deficit, and other factors raised substantial doubt about its ability to continue as a going concern. Solyndra itself, in its public filing at the SEC in September 2009, offered 22 pages of reasons why it might fail. In case anyone missed the point, the report included a table of financial and operating data for 2006 to 2009, showing 6 different measures of gross and net losses, not one positive outcome. On May 24, 2010, Valerie Jarrett, senior advisor to the president, forwarded a blog post by Philip Smith in Clean Tech to Ron Klein, chief of staff of Vice President Biden. The report outlined the doubts of PricewaterhouseCoopers. The post stated, quote, on a pure business analysis, you have to agree with the auditors. They are not a going concern. Valerie Jarrett said to Klein in an email, quote, as you know, a going concern letter is not good. Thoughts? Although Jarrett and Klein knew that Solyndra would go under, 2 days later, on May 26, 2010, the president visited Solyndra and declared, it is here that companies like Solyndra are leading the way towards a brighter, more prosperous future. By January 2011, it was clear to many that Solyndra was going to fail. Still, the Department of Energy helped shore it up by allowing it, as we heard in the previous panel, to draw on another $68 million in government loans. In addition, the department signed off on a restructuring agreement that allowed $385 million in government loans to take a back seat to $75 million in new investors' funds. In the restructuring, the $75 million from investors became senior to all government debt, except $143 million. Although objections were raised from OMB and the Department of Justice, the Energy Department paid no heed. On August 16, 2011, an unnamed official wrote in an email to Mary Miller, Assistant Secretary for Financial Markets at Treasury, quote, the Title 17 statute and the DOE regulations both require that the guaranteed loan shall not be subordinate to any loan or other debt obligation. The DOE regulations state that DOE shall consult with OMB and Treasury before DOE grants any, quote, deviation from the requirements of the regulations to the extent such requirement is not specified by the statute. That would constitute a substantial change to the financial terms of the loan guarantee agreement. But I will bet a quarter that the DOE lawyers have some kind of theory on how whatever restructuring they have done and whatever they are considering does not violate these requirements. Can't wait to hear it, unquote. The question before us is, why is the government under pressure from voters and credit rating agencies to reduce the budget deficit, issuing these loan guarantees at all? That's why this No More Solyndras bill is so valuable. One answer we hear repeatedly is fear of China, the new Red Scare. Now America is throwing billions of dollars at renewable energy, electric cars, concerned that China is getting ahead of us and stealing our jobs. But China is not using solar energy for its electricity production. As of 2008, 70% of China's energy came from coal. Wind and solar provide less than 2% of power for China's electricity. If we're afraid of China's growth, domestic industrial policy is not the answer. Rather, we should improve economic growth through more efficient tax and regulatory policies and increased use of our own domestic resources, such as coal and natural gas. Thank you for giving me the opportunity to testify.
Thank you. Mr. Berlin, welcome.
Good afternoon, Mr. Chairman, Ranking Member DeGette, and members of the subcommittee. My name is Ken Berlin. I'm Senior Vice President and General Counsel of the Coalition for Green Capital. The Coalition has been working on the state and national level to establish what are now commonly called green banks. And they are basically funds that provide low-interest loans to clean energy and energy efficiency projects. In particular, we've been working in a part of the market that's really not been discussed yet today. We are working to provide low-interest loans to very low-risk energy generation projects such as wind and solar generation projects. As such, we're not seeking to provide this financing because commercial banks find the project is commercially too risky. Instead, what we're trying to do is provide funding because the clean energy projects we're dealing with need to lower their costs so that they can deliver electricity first at a price that doesn't raise costs to consumers, and second, still allow an adequate rate of return for investors who want to invest in the project. Because we have a rate at which you can buy electricity, and because investors have to get a rate of return, the only way to put all this together and get an adequate rate of return is lower the cost, and that's what we're trying to do in these projects. I'm pleased to report that in looking at green banks in this way, we're getting very, very strong bipartisan support. We passed the nation's first green bank in Connecticut in 2011. It passed the Connecticut Senate 36-0, and the Connecticut House 139-8. The Waxman-Markey climate change bill in the amendment approved strongly by this committee included $7.5 billion of seed capital for a national green bank that passed on a bipartisan basis. And we're working now in probably a dozen states, working very closely with both Democratic and Republican legislators to establish these banks. Now, why are we getting this kind of support even though we're providing low-interest loans to banks? And I think there are a couple of reasons. I lay out 6 in my written submission, but I just want to summarize a couple of them. First, energy industries have been, as we all know, core industries in this country for many, many years. And all those energy industries have received government support where needed. The clean energy industry is one of the potential great industries of the 21st century. It's going to be a gigantic industry in the United States and around the world, and we think it deserves and needs support at this point in time. Second, by providing this support, we are low-cost financing. We're benefiting everyone in the market. It helps consumers by lowering the kilowatt-hour price of electricity. It helps private owners by giving them access to capital. It creates jobs and economic value by moving these projects from the board to the construction phase. It also helps, and we think this is very important, the private sector spending and private sector investment in research and development and R&D. Since greater demand for current technologies sparks a virtuous cycle that will lead to next year's and next decade's breakthroughs. Most new breakthroughs in the energy area aren't great discoveries where all of a sudden you get a new energy technology that's cheaper than anything out there. They slowly develop over time. And it's our view that if you want to create innovation in this industry, you have to work with these technologies to bring as they come down the cost curve. So what we're trying to do is lower the cost of these projects so that, in fact, they can come down. And, in fact, all these technologies are coming down the cost curve. at a very, very rapid rate and will eventually be fully price competitive on their own. Meanwhile, we're getting technology innovation as we go forward. We're also, in doing this, really trying to meet a demand from the states. Approximately 30 states now have renewable portfolio standards. There's very strong demand to build clean energy for many, many reasons, including sustainability, clean energy, and other reasons. What we're doing by providing low-cost loans is making sure that states can implement these renewable portfolio standards without raising the cost of electricity to their consumers. Loans may not be enough on their own, but at times they are, but they certainly make it much easier to reach those kinds of results. The key mantra in what we're doing in all this is that we have to be repaid on these loans. We're working in an area where there's very low risk, there's tremendous experience in how these projects work. You can do potentially much more risky loans, but to do that, you need something very different. You need a different economic model for the loans. You need a model that takes into account some projects will fail. You need a portfolio approach. We think those kind of loans should be separated out from low-risk loans, and they should be put in separate windows if we do a green bank. And we think we need consensus in Congress. Congress has to be willing to work on manufacturing projects and get the benefit from encouraging manufacturing in the U.S. What we would like to see avoided is a situation that we have now where the United States has developed most of the major solar technologies in the world. As of today, we don't have a single one of the largest 10 solar manufacturing companies in the world in the United States. Actually, one's here, but it produces outside the country. We want to see those technologies come back. We want to see manufacturing develop too. But the Green Bank primarily is working on low-risk technologies. Thank you very much.
Thank you, and I'll start my questions. Ms. Furchtgott-Roth, the President of the United States in a press conference criticized me. He said the chairman of the Oversight and Investigation Committee thinks we can't compete with China in the green energy policy. I think he's wrong, and I think the United States can compete. Isn't it true that China is not using solar energy for its electricity production?
That's true. Less than 2% of Chinese electricity production is from wind and solar and other renewables. 70% is from coal.
Isn't it true also that China is importing coal from the United States to meet their electricity needs?
That is correct, and they want to import the oil from Canada that we cannot have down here because the Keystone Pipeline has not been approved.
China is subsidizing their solar industry pretty significantly. I understand it's $30 billion. Is that correct?
Yes.
Is China producing solar panels and wind turbines for their own use or to export to America?
They are using some for their own use, but most of it, the vast majority, is for export to America.
So what they're doing is subsidizing an industry to make it cheap so they can export to America.
That's right. So we can produce more expensive energy, whereas they have the inexpensive energy that powers their economy.
So if the President is criticizing me for saying we can't compete with China, it seems like a non sequitur because China is really just subsidizing so they can compete with us and sell it to us cheaper than we can manufacture. Would that be a fair estimate?
That is correct, yes.
Then why should the United States try to compete with China when they're not really trying to do it themselves and they're relying on coal, which we have an abundance of? So what would you say to the President after he said that he thinks we can compete with China?
We can compete with China on many, many ways. We do not want to implement wind and power and solar energy. The Chinese are not doing that. The best way for us to compete with China is to use our own coal, use our domestic resources. We have far more innovation than China does. We have far more creativity, and these are the ways in which we compete with China, not by putting in place expensive forms of energy that drive up energy costs for American households.
Okay, let me ask you a little tougher questions, which will come from this side. How do you respond to proponents of federal loan guarantees who contend that unless the United States government subsidizes clean energy projects, the U.S. will lose the clean energy race to China or Spain?
Clean energy projects haven't been successful in Spain. They are not competitive energy-wise here. In a couple of weeks, households around the area are going to get their electricity bills from the heat wave. They're going to have very high electricity bills from keeping on the air conditioning, those who did not lose their power. If we had wind and solar powering our electricity, their bills would be 2 or 3 times as high.
But you hear Mr. Berlin say we're into a gigantic industry of this green energy. Let me ask Mr. Kreutzer, how would you respond to the proponents of federal loan guarantees who contend that loan guarantees do not cost the government much since the loans are supposed to be repaid?
Well, unfortunately, we have seen that they don't always get repaid. The Solyndra loans costing us, it looks like, over $500 million. Indication is that they're not going to get much out of bankruptcy. Abound Solar, not going to get much out of it. So we see a pattern of the loans not being repaid, but I think even more fundamentally, we see loans going to people that don't need loan subsidies. We're giving loan guarantees to companies worth tens and hundreds of billions of dollars.
I think that was in your opening statement. You talked about the federal government providing loan guarantee to companies worth $10 billion, $20 billion, $200 billion to finance projects.
Right.
So why should the United States government go to the free market to have market caps that are $200 billion? Why is the President talking about doing this under the Section 1705 program?
Yeah, I don't understand why myself. And I saw Mr. France at a presentation saying that two of the criteria that these loans had to meet was they had to be commercially viable and they had to demonstrate they couldn't get private financing. Well, those are mutually exclusive. You can't have a project that is both of those. So you're going to be funding one or the other. You're going to be funding projects that aren't commercially viable, which you don't want to fund, or you're going to be funding projects that could get private financing if they were viable. In either case, we shouldn't be funding them with guarantees.
What we have is a discussion draft here with no more Solyndra bill legislation. We're trying, Mr. Upton and I are trying to come up with it with the help of all the members here.
Yeah.
Do you think in this package we should put some criteria that if any loan guarantees go out, that subject to the market cap, or if a company's worth $200 billion, it shouldn't get? I mean, is that a criteria we should use? Do you feel strongly about that, or is that just?
I feel more strongly of just not having them go out. I don't think it's an appropriate area for government activity to guarantee loans for commercially viable projects. This is not a loan program similar to basic research, which is a completely different question. But trying to come up with a loan program for commercially viable projects is one that the government shouldn't be involved in.
Because it's picking winners and losers, so to speak.
Picking winners and losers, yes.
I'll just conclude by...
Get order, Mr. Chairman.
Yeah, I'm in the chair, Mr. Waxman. My only point then is if the government goes out and gives these money to small companies, you're recommending they give the money to research and development that would impact the innovation in this country, rather giving it to companies that have a limited market cap or viability. Isn't that what you're saying?
The closer the research gets to the basic fundamental research, the better the argument is for government involvement. The closer you get to the market implementation, the worse argument there is for government involvement.
All right, thank you. My time's expired. And Mr. Waxman.
Thank you, Mr. Chairman. I want to ask some questions about this proposal that's before us, because we have a very specific bill. Mr. Berlin, the Republican loan guarantee bill would change the program. The loan guarantee program itself was created to support innovative research, innovative energy technologies, and that's why Congress established a program on a bipartisan basis in 2005. Under this bill, the program can continue to issue tens of billions of dollars in loan guarantees in the years to come, but this bill prohibits DOE from considering any applications for loan guarantees submitted after December 31, 2011. So the Republican bill creates a winner's list of a few dozen projects that are eligible for future loan guarantees. Those are the only applications DOE can ever look at. Any project not on the list can't get a loan guarantee, period. It doesn't matter how groundbreaking the technology is. If it isn't on the winner's list, it can't receive support. Does this approach make sense? Should Congress prevent DOE from considering new applications for breakthrough technologies?
I think it's very important for us to think through how we want to encourage innovation in the United States and how we want to get innovative new technologies built and developed. And I think that there are situations where there is a need for government funding to help get these kinds of projects off the ground. And
you wouldn't limit it to just those applications that are sitting there now?
I'm sorry, I apologize.
You wouldn't limit the loan guarantees only to those applications that
No,
are sitting at
because
DOE right now.
for as the reasons people have said, if you accept that there's a need to support innovation, it doesn't make much sense, in my view, to cut it off now when you might have a new innovative project that comes up tomorrow that's better than a project you have in the
This
pipeline.
bill throws innovation out the window, and it replaces it with a static list of winners who happen to submit applications by the end of 2011. Dr. Kreutzer, you wouldn't want this bill to continue funding projects that are at DOE now. You don't think we ought to have a loan guarantee at all, isn't that right?
If we're talking about going forward, I'm not sure we want to go back and undo things and agreements we've already made.
No, these are not agreements.
There's going to be a point someplace.
These are not agreements that we've made.
Right.
These are applications for loan guarantees. Well, and so the bill allows more loan guarantees, but only for those that are pending at DOE. Do you think that makes sense?
Well, I think you have to have a cutoff point at some place. If you want to go back and cut it off the ones that have already received the loans, you know, that would be one case. I don't know that that's less picking winners and losers than having a cutoff at December 31st. That's a separate question. I'm generally arguing that loan guarantees are a bad idea from the government, that innovation will take place in private markets.
If we agree with you, then we should just end the program. Isn't that right?
Yes.
Okay. Mr. Berlin, the premise of the Republican bill is that the loan guarantee program has been a big failure. What do you think? Has the overall portfolio of projects been a failure?
Well, one of the studies I've read estimates that about 87% of the projects that have been funded by this really fit in the low-risk category. They're energy generation projects. We should see major developments, for example, in large-scale solar projects as a result of the legislation. So I certainly would not call it a failure.
Some argue that the government has no role to play in supporting next-generation clean energy technologies because these technologies are inherently risky, or they could get their own capital, and they don't need government intervention. Some of the same people say we should continue using taxpayers' funds to provide subsidies to well-established oil and gas companies that have received government support for decades. Mr. Berlin, how can the government best create a level playing field where new clean energy technologies can succeed?
Well, again, I think new energy technologies do need subsidies for the reasons that I said earlier, which is they come in when they're first developed. They come in at a more expensive level almost every time than existing technologies. We know they're going to move down a cost curve. That's what happened with existing technologies, and we have to bring them down the cost curve so they become competitive. And at the end, there will, in fact, be a very, very large worldwide market for these technologies. I don't agree, for example, that China is not putting solar in place in China. They're putting considerable solar in place. I don't agree that they're shipping solar to us at a much cheaper price than we could sell in the United States. Has raised the cost of energy more than if they had not shipped to the United States. So I do think we have to be involved in this effort.
I'd like to ask Ms. Furchtgott-Roth, do you think we ought to continue subsidizing oil and natural gas through the tax breaks that we give them?
I don't think oil and gas should have special tax breaks. I think they should have the same tax breaks as other domestic manufacturing or other industries such as the pharmaceutical industry.
You just think we ought to have a level playing field and let everybody compete. Is that right?
Exactly, yes, yes. And just as the domestic manufacturing has a 9% deduction, I think oil and gas should also, being a domestic manufacturer, have a 9% deduction. Instead, it has a 6% deduction, and President Obama wants to get rid of that. That puts it on an unlevel playing field with the rest of domestic manufacturing, which would be unfair to the oil industry.
And Dr. Kreutzer, do you agree with that?
I absolutely agree with that. The Section 199 tax deduction, where you get the big numbers that are called the oil and gas subsidy, the domestic solar panel manufacturers, windmill manufacturers, newspaper companies, they all get this 199 deduction. And as Mr. Furchtgott-Roth pointed out, they get a bigger one. So it's not, I think it's disingenuous to call that an oil and gas subsidy.
Okay, thanks. Thank you, Mr. Chairman.
Mr. Whitfield.
Thank you very much. I want to thank the panel for being with us this afternoon. And I want to ask you, Dr. Kreutzer, and Ms. Furchtgott-Roth, realizing that this legislation, the No More Solyndras Act, may not be perfect, but would both of you agree that at least it's a step in the right direction? Dr. Kreutzer?
Yeah, at Heritage, we're not allowed to support or oppose specific legislation, but I think the policy of cutting off loans is a good one. The fact that you may not cut them off at the exact same point that I would choose doesn't mean it's not a good idea.
Ms. Furchtgott Roth.
Yeah, I think it's a great bill, and companies play along with the rules that they are given. Up to now, we've had the rule that we have had loan guarantees available. Companies have gone to a great deal of trouble of putting together applications. It seems sensible to allow those who've made that investment to still be on the list. It's not a matter of picking winners and losers. It's a matter of the time invested by those companies. Then after December 11th, the program's cut off.
Mr. Berlin, in responding to Mr. Waxman's question, talked about that he thought maybe 87% of these projects out of the 1705 loan guarantee program had been successful, and that was because a lot of them were low risk. That's one of the reasons that I'm quite concerned about this program, because most of those very significant loans were made to well-capitalized companies, most of them on the New York Stock Exchange, like Google, General Electric, subsidiaries of Berkshire Hathaway, Goldman Sachs. And at a time when we have a $16 trillion federal debt, and this president particularly talks about protecting the middle class, why would we be making loan guarantees to companies that strong financially? Dr. Craig.
I would agree with Mr. Chairman. It gets back to the false premise on which the loan guarantee was based, that there are market viable projects that can't get private financing. They simply don't exist on a regular basis. If it is a low-risk project and you have a well-capitalized firm and it's market viable, they shouldn't need a guarantee. There should be private financing for it.
Dr. Roth, Ms. Roth.
Yes, I would certainly agree with that. At the time the program was put in place in 2005, we had no idea that we would have a 200-year supply of natural gas at about $2 per million BTUs. We were concerned about energy security. With our domestic resources now, with the great American revolution, energy revolution that's occurred the past 3 years, we have immense supplies of inexpensive domestic energy. We don't need this program anymore.
Well, you know, people who support 1705 say, well, it was a bipartisan bill in Congress, and that was a number of years ago. It was approved, but I can tell you what, if we were voting on that today, because of today's current financial situation in America, I do not believe the results would be the same. Now, when we have debate here in this committee about regulations coming out of various federal agencies and the purpose of the stimulus funds, we hear about creating new green jobs. That is what everyone talks about. And I've heard comments that, 3 million new green jobs have been created. And when I read some of the definitions of new green jobs, like antique shop workers because they're recycling, septic tank workers, janitors, bus drivers, teachers of environmental studies, that's totally misleading the American people. So let me ask you all, do you think that these stimulus packages and these loan guarantees have been successful in creating significantly new green jobs for America?
I would say no, and I would say they certainly don't create jobs in aggregate, because you subsidize one group, you have to take the money from someplace else. But when you start looking at that green jobs count, it wasn't just the categories of green jobs, but it was the volume. Over 50% of the jobs in steel mills were counted as green.
Right.
There were 33 times as many green jobs in septic tank and portable toilet cleaning as in solar utilities. So the 3.1 million, nobody should even say that number with a straight face any longer.
Well, go ahead.
I would agree with that. A large part of the 3.1 million green jobs is relabeling. People who produce this cup that has the message, we have the power to save energy, that counts as a green job because it has an environmental and educational message on it. If the cup, on the other hand, just had architect of the Capitol on both sides, its producers would not have green jobs. And this number is a fraudulent number. It is imprecise. It shouldn't be used.
And the American people are blatantly being misled. But thank you.
Mr. Sarbanes from Maryland.
Thank you, Mr. Chairman. If the panel would bear with me for one moment, I wanted to return to some earlier testimony Mr. Scalise earlier repeatedly claimed that the Department of Energy had received a legal opinion from outside counsel that determined that subordination was illegal, and I'd like to make this part of the record. Mr. Scalise's claims are incorrect. The committee received a rough draft of a contractual and legal analysis produced by DOE's outside counsel. This document noted the language in Section 1702 prohibiting subordination during the origination of the loan, but it did not speak to the DOE legal analysis, which concluded that subordination of the loan during restructuring was allowed under the law. The document is not a legal opinion, and it does not declare subordination to be illegal in a restructuring scenario. The committee staff interviewed the loan program's chief counsel for nearly 6 hours. In those interviews, she indicated that outside counsel, as well as the general counsel of the Department of Energy, reviewed and concurred with the legal opinion that subordination during restructuring was allowed under the law. Furthermore, Mr. Chairman, the minority reached out to a former general counsel of the Department of Energy, now in private practice. She conducted an independent analysis of the subordination question and found DOE's opinion to be proper and correct. All of these documents have previously been made public. In order to set the record straight, I'd ask unanimous consent to introduce the outside counsel's rough draft analysis document, 2 subsequent emails from DOE's outside counsel, DOE's formal legal opinion, and the opinion of the former DOE general counsel into the record of this hearing.
It's already, my staff has said it's already part of the record.
Well, in the event...
Secretary Chu, we had him up, we put that in part of the record. I don't see it. So
Mr. Chairman,
unanimous consent, let's put it in again.
Great, thank you. Now moving to the panel with my remaining time. Dr. Kreutzer talked about 2 categories of projects, and he suggested that there are only 2 categories of projects in the world. One are those that do not require government support through a loan guarantee program or otherwise because they've got the sort of backing out there that would allow them to move forward. In the absence of that, and the other category of projects are ones that are not commercially viable. And he implies that that those projects can only be ones that are never going to be commercially viable. But I think we need to parse that further, divide it into 2 subcategories. Those projects that may never be commercially viable, and obviously you'd want the department to scrutinize it, to try to ascertain that on the front end, if possible, because sometimes you never know. But I think there's another category of projects which are not yet commercially viable. In other words, for purposes of the launch of that technology, you would say, well, if they were launching by themselves with no kind of guarantee or other supports, there's no way they could make it in the market. But the fact that they're not yet commercially viable does not mean that they will never be commercially viable. And I'd like you, Mr. Berlin, to speak to that because, you move in a space where analysis of what can be viable if you get it launched is done all the time. My understanding is you participate maybe after the launch stage in bringing things that are already kind of out in the market, bringing that cost curve down over time to accelerate the competitive position that they can hold relative to the rest of the market. But certainly you must have a view that there has to be a category of projects, while maybe not yet commercially viable, certainly could be one day, and that's the role that can be played by these very valuable and important loan guarantee programs.
Yes, I mean, I 100% agree with that. We're actually a nonprofit with setting these up, so we're not doing this directly ourselves. But I think if you look at wind and solar technologies right now, they are more expensive. The delivered cost of electricity from wind and solar projects without subsidies is higher than delivered cost of electricity from existing generation. There's virtually no doubt in my mind that over time, these projects will become fully competitive. And what we really mean in the real world when we talk about commercially viable now is this. Let's say we have a project out there and a company looks at it and says, if I build this project using commercial loans, I will get a 9% rate of return. I'm not going to do a project unless I get a 10% rate of return. because that's the minimum that I'll do a project. That's the reason you help big companies sometimes in this, because otherwise they just won't do the project. So we come in as a bank and we say, we want to put a tranche of that loan, a percentage of that loan at a low interest rate, so we can bring the cost down so that both the project sponsor will build the project and the consumers will get energy at a price that's competitive with their current price. So it's both. One is the division may be very small before things are commercially viable, but even where it's larger, like in some of, in some of the technologies, those costs are coming down. If you look at the curves on all those, they're all coming down. And if you look at the history of the energy industry in the United States, we've subsidized every technology. We have the same problem with nuclear now. We have the same problem with carbon capture and sequestration as we do with clean energy. If we want to develop those projects, we will ultimately have to, and I'm not making a choice whether we want to, but if we want to develop those, we have to figure out a way to bring those things down the cost curve. Hopefully they'll get there. We don't know for sure with those. We do know they'll get there with wind and solar.
Thank you.
The gentleman's time has expired, and the gentleman from Texas, Mr. Olson's recognized for 5 minutes.
I thank the chairman, and good afternoon. I thank the panelists for coming back. I appreciate your patience and persistence, and most importantly, your expertise. And I represent Texas 22, which is a suburban district, the home of the Johnson Space Center human space flight. And so using an analogy from back home, the people I represent are outraged. They're angry that $500 million of their taxpayer money was so callously wasted on loan guarantees that the administration, the people of Texas 22 knew were as risky as betting our future space exploration on 3 magic beans. It's my job to get them answers of how this money could be so callously spent. And I appreciate your insights to help me respond to them. So my first question for you, and I apologize if I get this wrong, Mrs. Roth? Close enough? Please, one more time, ma'am? Scott.
Yeah.
Scott Roth. I apologize.
Not at all.
I was intrigued by your testimony. Your testimony mentions the perils of quote-unquote industrial policy. Could you elaborate on what you mean by industrial policy and why policymakers should be very wary about going down this road?
Yes, industrial policy is picking winners and losers. For example, there are many projects in the United States that are not commercially viable right now that might be in the future. We have venture capitalists, we have private equity firms. It's up to them to choose which of these ventures to invest in, not the federal government. The federal government has a role in basic research, but not in investing in enterprises that might someday be profitable. Amazon.com, for example, when it started out, was not commercially viable. It became commercially viable over time. It's a blockbuster now because of private funding. This little BlackBerry 201, it probably wasn't very commercially viable when it was first started out. Now many people have them. It might go down because RIM is having trouble. It doesn't mean the federal government or the Canadian government should be propping up RIM.
Do you believe the Obama administration has learned a lesson from the bankruptcies of Solyndra, Abound Solar, and Beacon Power, or do you believe they simply double down going forward here?
Well, I don't think that they were investing in these for cost-benefit reasons. They were investing in it for political reasons because some of their supporters, perhaps their campaign contributors, such as George Kaiser with Solyndra, had an interest in these projects. So I do not think they've learned their lesson. There are always pressures for the government to invest in worthless projects, and it's up to all of you to take a stand against it.
And so you're saying some political operations or some political pressures are being forced upon the administration. That's why they've made these decisions that weren't economically viable in our market, free market economy, correct?
I believe that that is one reason, yes.
Any idea why, the Bush rejected the Solyndra proposal late in January of 2009, and yet the Obama administration revived it by March of 2009. Any idea why they revisited Solyndra as being economically viable at that time, why they thought it could make money?
George Kaiser was a big investor in Solyndra. He made many visits to the White House, which are documented in White House records, and that is perhaps one reason. You can read the entire email trail where there was pressure to have Vice President Biden appear at a Solyndra event in September, and that was why there was rush. Many OMB Korea officials were on record as saying this was too rushed, and they did not approve of the project. DOE apparently overruled them.
Yes, ma'am. There was evidence that when Solyndra announced that they were going to close down some of the manufacturing facilities, that they delayed the closure until November 3rd of 2010, the day after the election. A question for you, Dr. Kreitzer. I just want to ask, who's better suited to discover commercially viable investment projects, private investors or the Department of Energy?
I would say private investors. They're subject to a discipline that the Department of Energy is not. That is, they get a great reward when they hit a home run, and they suffer a penalty when they strike out. And so they have a huge incentive to make sure they're sorting out as best as they can the home runs from the strikeouts. And the Department of Energy does not have that same discipline on them.
How do you respond to proponents of federal loan guarantees who contend that, similar to venture capitalists, some loss of taxpayer money should be expected in financing risky ventures?
Well, it's funny. Venture capitalists have equity positions so that when they get the home runs, they get a whole lot of money. And maybe that's how they cover the cost of the losses. We're lending it essentially at treasury bond rates almost to high-risk ventures. That simply doesn't make sense, certainly not if you're a venture capitalist. It doesn't make sense if you're a taxpayer either.
Thank you. I'm running out of time here, but thank you for your questions. I appreciate, again, your patience and with us going through the votes. Yield back.
Thank you.
Recognize the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. And Mr. Chairman, I know in our subcommittee typically we swear witnesses, and I'd like to ask Ms. Furchtgott, Roth, you made some statements about, and you, Ms. Dr. Kaiser, also about how this decision was made. Are y'all privy? Either of y'all privy to information on how this decision was made?
I don't believe I've made any comments on how the decision was made. I've talked in general about markets versus government, but I have no opinion on the motivation behind it.
Okay, because our investigators did a lot of investigating, and your testimony is directly conflicting what our investigators said. So I need, Ms. Furchtgott Roth, do you have any individual information that maybe would help us on this? You made some statements about the decision was made, somebody made a visit to the White House, and that a great many of the Department of Energy staff opposed this. Is that true? Did you hear that from somebody?
I made the statement that the Office of Management and Budget staff opposed approving Solyndra. That is in the emails collected by your committee and that have been released to the public. I also made the statement that George Kaiser was a major contributor to President Obama's campaign. That is a matter of public record, that he made numerous visits, and I have the number, to the White House before the loan was approved. That is also a matter of public record.
Some of the judgments you're making is based on that information.
Correct.
And but I have to admit I was disappointed, as my colleagues are, about the Solyndra problem. But I also know that this law we have was passed by this committee in '05. And frankly, the members that are here today, except for my colleagues that are new, Congressman Olson, actually supported this law in '05 that put these loan guarantees in place, and I supported it also because I'm a big one for nuclear power in our country, and that was part of it. Of course, I also come from Texas, where we've had such huge expansion of wind power that's been not only based on state assistance but also federal assistance, because we made a decision that that's another way we can be the energy capital of the world, that and whatever it's called, whether it's oil and gas, energy, nuclear, I'd love it to be in Texas. But let me just say that in 11 interviews with career staff, about 50 hours, there was no evidence that our staff could come up with that there was any Kaiser influence on the approval at the Department of Energy. And you acknowledge that. You're shaking your head yes, so I assume that you acknowledge that.
Oh, it's probably just a coincidence that Mr. Kaiser made so many visits to the White House and that he was a major investor. It's probably just a matter of coincidence. I acknowledge that.
I've been around here a long time, and a lot of people visit the White House for lots of things, and you know, if I'm sure there would be more information if we could do that. Let me get back to some of the concerns I have, though, about in China, and I know that was heard earlier. China's investing, and somebody invested in a lot of companies in China. The top 10 solar panel producers are from China. Is that correct?
I don't have the precise number in front of me.
And China's not a free enterprise country, so I assume the government of China or the People's Army invested in that. So wouldn't that be a significant amount of government support in China for solar panels?
Yes, it does have a significant amount of government support, but it doesn't mean that we need to support it here.
Well, let me give you an example, though, that one of the reasons, and would you, either of you or all three of you, part of the problem Solyndra had was that they were producing panels that could not compete with Chinese solar panels.
Solyndra couldn't compete with solar panels made in the U.S. They were the high-cost producer even in the U.S. So with or without China, they did not have great prospects. All right,
Okay.
they had a new technology, and its competitiveness depended on the polysilicon prices staying very high and getting higher. Had really, they could have gone out of business anyway. But in any event.
Well, but again, the top 10 solar producers in the world are in China, and they have access to our market.
I don't think we should take China as the economic model to follow.
Oh, I agree.
Okay.
In fact, I believe in our free enterprise system. If somebody loses money, they lose it. But in China, if you had lost $500 million, I don't think we would see you ever again, because that's the punishment.
Perhaps. I don't have, not an expert on Chinese law.
I know people talk about in Texas we have the death penalty. We do have appeals processes. Sometimes China imposes a penalty before you could ever have an appeal. Let me, Mr. Berlin, I thank you for coming here today. I come from Houston and East Harris County, and we have energy economy. I have 5 refineries and 20-plus chemical plants, and what I don't have, my colleague Congressman Olson has. We're primary oil and gas, but our port and our chemical manufacturers stand to benefit also from alternative energy sources. I remember a few years ago, there was a hesitation on doing cogeneration 25, 30 years ago. And now most of my plants use cogen in their area, which we were working in an energy bill to get them credit for the savings they would get from using cogeneration. So I'm seeing a change in the industry that's all of the above. And even though oil and gas doesn't get loan guarantees, but and I agree with your opinion on the tax issues, because I've said that the same thing. All we want is the same domestic manufacturing tax rate that everybody else pays in the oil and gas industry. But the Republican bill on the loan guarantee effectively ends the program. And is the loan guarantee program good policy? I apologize, Mr. Chairman. I've run out of time.
Time has expired, and recognize Dr. Burgess for 5 minutes.
Thank the chairman for the recognition. Mr. Berlin, I thought my miracle ear had messed up. Did you say that there was bipartisan support for an amendment to the Waxman-Markey bill? Did I hear you say that correctly?
The amendment that included the $7.5 billion for the Green Bank, I think passed through this committee as part of it. There were other provisions included. I think it passed through 44 to 8 or something like that in the committee.
But
not in the committee, in the committee, not
on the floor, because the bill came up under a closed rule, and we were not allowed.
I'm sorry,
one of the big objections. We were not allowed to amend Waxman-Markey as it came through on the floor of the House.
Committee.
Okay, Ms. Furchtgott Roth. I mean, as you know, I drew attention to some of the memos as well when we were questioning the other witnesses. And just for the point of emphasis, you have a witness, I mean, a evidence binder at the table there. Under tab 7 is, I believe, the email which you referenced, which is an email on August 31st of 2009. The names are redacted, but my understanding is this from an Energy Branch Chief at Office of Management of the Budget to his immediate superior, issued 4 days prior to the closing of the loan on Solyndra. And in the email it says, I would prefer that the announcement be postponed. The credit crew is out on leave this week. This is the first loan guarantee. We should all have a full review and all hands on deck to make sure we get it right. Furthermore, the announcement this week would require us to have a waiver to the requirement in the rule that 30 days elapse from when the final credit rating is submitted, setting a bad precedent. So it sounds like the system was blinking red. It sounds like the traffic cop held his hand up and said, stop, don't do this. What we don't know, and what this committee has endeavored to find out, is where the pressure was coming from to make that decision so important that we couldn't even follow the simple rules that were outlined for this procedure. Is that one of the points that you were trying to make in your testimony?
That is correct, yes.
And it has been so hard to get the information. The committee staff has made inquiries starting back to when the Republicans gained a majority in the House and gained the majority on the committee, beginning with those document requests back in February. By July, we had members of members of the Office of Management and the Budget, members of the Department of Energy who were no-shows to our committee when we were trying to get answers to some of these questions. The very first emails were kind of dribbling out and we were getting these impressions, but it was because the day we were to have that hearing, this witness table had no witnesses, that I was forced to offer a resolution leading to the subpoenas that then allowed us to get the information that you were quoting. So it is disingenuous for anyone to say that this committee has not done its work of oversight, its constitutionally authorized work of oversight, in order to, no, not just embarrass an administration, but to find out where the problems were. Because this sounds like someone was saying, whoa, and someone else off stage was saying, go. And that, of course, has been what this committee has been trying to discern. I can't say at the end of the day if we will ever identify the person with their fist on the go button, but clearly that's what was going on. And then the other part that's so important about this email, and we heard the testimony on the other panel that, oh, wait a minute, hindsight, you can always do good in retrospect, but you didn't, the foresight, I mean, the quotes, the citations at the bottom of the email. China racing ahead of U.S. in the drive to go solar. Right. Chinese solar firm revises price remark. As prices slump, solar industry suffers. More sun for less. And each of these titles is followed with a website, New York Times, Green Ink blog, New York Times. Each of those is followed with a website that was easily referenced by anyone who received this email. Again, the system was blinking red. You are going down a road where the price is being undercut by a foreign competitor, and whether it's legitimate or not, whether it's an adverse government subsidy on the part of the Chinese, nevertheless, the market is in peril. Would you agree with that assessment?
Yes. Well, I would agree. Those emails are absolutely right, and there are many others that you could have quoted that also demonstrate this same issue. 2005 was a very different time. I think now it's clear that solar panels are solar power is a far more expensive form of energy. Whenever the government is in charge of giving out money, then there are always going to be pressures to pick winners, not do it on a straight cost-benefit analysis. That's why this bill, No More Solyndras, is so valuable, and I very much hope that it becomes law.
Yeah, and it's just so far, you know, Valerie Jarrett should have been here in our committee, or at least been answered questions from the committee. Mr. Klein, same thing. This has been a frustrating process from start to finish. The administration has violated the Lanny Davis principle, and when you got bad news, you get it out early, you get it out often, and you tell it yourself. I think they should learn something from this experience. I'll yield back the balance of my time.
The gentleman's time has expired, and we recognize the gentleman from Massachusetts for 5 minutes.
Thank you, Mr. Chairman. Just to restate Mr. Berlin's point down there, the vote on the Green Bank in the Energy and Commerce Committee in 2009, and that Green Bank was included in the Waxman-Markey bill, was 51-6, including an affirmative vote by Mr. Burgess on that green vote, just so that everyone has the history on that. But this is really a debate not over that, but really a debate over whether or not the Republicans really want to support renewable energy as opposed to any other energy source. Let's be honest. That's the real debate. So, Ms. Fritchcott-Roth, welcome back to the committee.
Thank you.
I'd appreciate answers to these questions, you too, Dr. Kreutzer. Do you agree that if a publicly traded company has been warned that it may be delisted from the stock exchange because its shares are trading at under $1, that the federal government probably shouldn't be giving a $2 billion taxpayer loan guarantee?
I've been tricked into these yes or no questions before because I don't know what the loan guarantee is.
If a publicly traded company is already been warned that it could be delisted,
okay,
should the federal government be giving a $2 billion loan guarantee to that company?
I think I've made it clear in the past that I don't think the government should be in the business of making loan guarantees.
Thank you. Ms. Fritchcott-Roth?
I don't think the government should give loan guarantees to any company, period.
Okay, thank you.
Delisted, listed, whatever.
Thank you. I got it. Thank you. Solyndra was given a B+ credit rating before DOE issued its loan guarantee, which means it was highly speculative. If a company had an even lower credit rating, for example, a CCC+ rating, which means it has junk bond status and is considered a substantial risk, do you agree that the government probably shouldn't be giving it a $2 billion loan guarantee? Dr. Kreutzer.
I think I've already answered that, yes.
Okay, thank you.
We have a $1 trillion deficit. We're borrowing 40 cents out of every dollar that we spend. We should not be in the loan guarantee business.
I am with you. Now, what about a project that is already predicting a 7-month delay and a cost overrun of almost $1 billion on a $14 billion project that has barely even begun construction? Do you agree that the government probably shouldn't be giving it an $8 billion loan guarantee if it's already basically doubled its costs?
I don't think the government should in general be in this. So I don't know how far down the road they are, if they're already signed agreements. You know, I don't think of the 26 loan guarantees that were done under here should be somehow pulled back. I think there needs to be a point where you say, here's where we stop.
Well, I'm not talking about hypothetical solar projects. I'm talking about 2 nuclear loan guarantee applications that this legislation does not preclude from moving forward. And I would like to work with the majority to preclude them from moving forward. The Department of Energy has given a conditional approval of $8 billion loan guarantee to the Southern Company to build 2 nuclear reactors that the Nuclear Regulatory Commission's experts warned could, quote, shatter like a glass cup in an earthquake. The department has also provided hundreds of millions of dollars of taxpayer money in bailouts to the near-bankrupt United States Enrichment Corporation, which still has a pending loan guarantee application before the department, but we've never had a hearing on these projects despite my repeated requests to do so. The 28 loan guarantees for renewable energy totaled $16 billion, and Congress appropriated $2.5 billion to cover the possible defaults. So 16% of the total loan value of these projects is backed up by hard currency of the Department of Energy. But DOE documents indicate that it is only going to require as little as $195 million, or 2% of the $8.3 billion nuclear power plant guarantee to mitigate the massive risks. Ms. Fritschkoth-Roth and Dr. Kreutzer, shouldn't the department require a much larger insurance policy before moving forward with these loan guarantees, given what we've just learned from the Solyndra incident and given the already very questionable history of these nuclear power plants?
I don't know the particulars of those loans and what would be an appropriate guarantee. I think I said that if I had it to start over again, we wouldn't have the loan guarantees in the first place. How far down we are the road with this and to what extent have they been committed, I can't answer, and I think the committee has put together a bill that has picked a point beyond which we no longer accept them.
Let me just interrupt right there and say we have recently begun to hear Republican complaints that some of the loan guarantees that were issued resulted in manufacturing jobs being created overseas. I'm hearing what they're saying, that these loans should not be issued to companies that plan to use the funds to outsource jobs. I'd just like to point out that both the United States Enrichment Corporation and the Southern Company plan to utilize many expensive foreign components. And I'm sure my colleagues will be as distressed about that as I am. And hopefully you'll work with me to make sure that the Southern Company and the United States Enrichment Corporation cannot be dealing with those foreigners, and so that we have the same policy for foreign solar panels and the same for the nuclear industry in terms of the foreign components that are used in our reactors. So just a little preview of coming attractions of the paradoxical nature of dealing with loan guarantees and trying to segment out solar from nuclear and pretend that there is an actually coherent policy which has been constructed. Thank you, Mr. Chairman.
Thank you. I just point out to my colleague that under the 1703 program, the nuclear companies must pay the credit subsidy costs, but under the Obama 1705, the taxpayers paid that cost for the companies. And with that, recognize the gentleman from New Hampshire for 5 minutes. Pass.
Mr. Chairman?
Yes.
I move to strike the last word for
by unanimous
a brief
consent?
observation.
Sure.
My question to Mr.
How about 30 seconds?
My question to Mr. Berlin was only to correct if anyone was watching this and got the mistaken impression that the Waxman-Markey bill was brought to the floor of the House under anything but the most closed of rules, and we were not allowed to offer amendments, even though leaving the Rules Committee there were 300 new pages of legislation added to the Waxman-Markey bill. That's why I was so startled by his comment. Yes, I will admit I occasionally veer off into supporting Mr. Markey in committee. I'll try not to let it happen again, and I'll issue my formal apology to
All
Mr.
right, with
Markey
that.
for that lapse in oversight and yield back.
Okay, we're going to let the second panel go and call up the third panel, if you would, and thank you for your patience as we had votes here, and we appreciate your participation. You want to take over, Ed?
He's been very helpful.
I want to welcome the third panel. I want to thank you for your patience, and we look forward to your testimony. On the third panel, we have with us Mr. Paul Chamberlain, who's Assistant Vice President, Energy and Campus Development at the University of New Hampshire. And I'd like to recognize Mr. Bass of New Hampshire because since he is from New Hampshire, I wanted him to make some comments about you as well.
Thank you very much, Mr. Chairman, and I want to also thank our witnesses today for their patience, and I want to thank you, Mr. Chairman, for having this hearing on what should be a common sense component of our nation's energy strategy, i.e. energy efficiency. As we will hear today, the Bipartisan Smart Energy Act would optimize the use of energy savings performance contracts to reduce the federal government's energy consumption and save taxpayers' dollars, as well as encourage economic growth and create jobs by promoting industrial energy efficiencies like combined heat and power. New Hampshire, I'm proud to say, is a leader in such technologies, and I'm pleased that Paul Chamberlain from the University of New Hampshire is here to testify today about their very innovative cogeneration system and its benefits to the university and to the people of New Hampshire. So with that, Mr. Chairman, I'll yield back.
Thank you. In addition to Mr. Chamberlain, we have with us today Mr. John Marone, Vice President, Energy Initiatives for St. Gobain Corporation. We have also Mr. Jeff Dries, U.S. Country President for Schneider Electric on behalf of the National Electrical Manufacturers Association. We have Mr. Stephen Nadel, Executive Director of the American Council for an Energy Efficient Economy. And last, but not least, Ms. Katara Callahan, President of the Alliance to Save Energy. So thank you for being with us. Each one of you will be given 5 minutes for a statement. And Mr. Chamberlain, we'll begin with you. You're recognized for 5 minutes.
Mr. Chairman, distinguished committee members, it's my distinct honor to appear before you today regarding energy efficiency and the University of New Hampshire's main cogeneration plant, which we installed to provide both power and heating to the university's main campus in Durham, New Hampshire. I hope our experience and perspective will inform the committee's deliberations on Representative Bass' bill, the Smart Energy Act. Mr. Chairman, prior to 2005, the University of New Hampshire was purchasing electricity from a local utility, and heat was generated in the form of steam in an aging central boiler plant and distributed to the campus by a district heating system. Rather than investing in an upgrade to the 1950s-era boiler plant, in 2005, UNH invested $20 million in a cogeneration system that would meet campus heating needs and provide electric power to meet campus requirements. This system has resulted in significant benefits. One, the total cost to provide utilities to the campus is lower. We estimate a $3 million savings in 2011. Two, air pollution emissions were reduced. Three, regional greenhouse gas emissions were also reduced. And finally, four, demand on the regional energy system was reduced. In 2009, UNH placed in operation our Ecoline system, a $49 million project to process and transport landfill gas
to the campus for use as the primary fuel in our cogeneration plant. Landfill gas is now providing nearly 70% of the total campus energy and 80% of the fuel consumed by our cogeneration plant. We believe our campus is unique among higher education institutions in using landfill gas as our primary source of energy. Cogeneration offers the opportunity to dramatically improve the efficiency with which fuel energy is converted to usable forms as heat or electricity, and thus reduces the demand on our electric supply. Settings where both forms of energy are needed, such as college or university campuses, industries that need both heat and power, cities that have central heating districts, military installations are well suited for cogeneration application. Locations where there is a large thermal need and the ability to connect to the grid are also offer the opportunity for cogeneration to meet local thermal needs with electricity being exported to the grid. In all cases, there is a beneficial effect on the grid by decreasing the need for peaking power necessary to meet system demand. The technology, in our experience, is mature, and again, in our experience, the equipment is highly reliable. Mr. Chairman, the UNH experience clearly shows that efficient cogeneration installations with balanced thermal and electric energy loads can dramatically improve the efficiency with which fuel energy can be transformed into usable electric and thermal forms. For this reason, I'm pleased to lend my support for Section 203 of Representative Bass' Smart Energy Act, which calls for the doubling by 2020 of the production of electricity through the use of combined heat and power plants and waste heat recovery, and the development of a strategic plan to achieve these energy efficiency objectives within the industrial sector. As the committee examines this set of issues, it should be noted that widespread application of cogeneration technology has distinct implications for the management of the power grid and application of regulatory requirements, and it is essential, I believe, that these issues be addressed comprehensively in order for the nation to fully exploit the energy efficiency and environmental benefits of cogeneration systems. The University of New Hampshire's experience demonstrates that moving to a cogeneration energy system is not an abstract idea. Rather, the university sets an example that other institutions and installations can emulate or follow if there is a strong commitment to achieve energy savings. That concludes my opening statement, Mr. Chairman. I want to thank the members of the committee for this opportunity to appear before you today, and I look forward to your questions.
Mr. Chamberlain, thank you very much, and Mr. Marone, you're recognized for 5 minutes.
Thank you. Chairman Whitfield, Ranking Member Rush, and subcommittee members, thank you for the opportunity to testify before you on Smart Energy Act. My name is John Maroney. I'm the Vice President of Energy Initiatives for Saint-Gobain Corporation. I'm here today to testify on behalf of Industrial Energy Consumers of America in support of the Smart Energy Act. We wish to especially thank Representatives Bass and Matheson for their leadership on the important issue of industrial energy efficiency. Saint-Gobain is the world's largest building material company as well as global leader in production of high-performance materials, glass containers, with sales of $58 billion in 2011 and over 195,000 employees. Here in North America, Saint-Gobain recorded sales of nearly $7 billion in 2011. We employ some 19,000 employees and more than 260 locations in U.S. and Canada. Industrial Energy Consumers of America membership is exclusive manufacturers who consume energy as fuel and feedstock to produce value-added products and to consume by every sector of the economy. Manufacturing consumes about 1/3 of all natural gas and electricity and employs roughly 12 million people. They also compete with tough global competition. In many cases, even a small change in price in energy directly impacts our ability to compete. It is for this reason that the Industrial Energy Consumers of America and its members companies advocate for policy that supports reliable and affordable energy, including cost-effective energy efficiency. Simplistically speaking, there are two ways a manufacturing company can improve their competitiveness and increase jobs. They either increase revenues or decrease costs. Improving energy efficiency is an excellent way to reduce the cost. After losing about 5.5 million manufacturing jobs since 2000 due to the loss of competitiveness and recovering only about 500,000 jobs since 2010, we have a long way to go. We believe that improving energy efficiency is a solid winning policy platform that will contribute to capital investment, emissions reduction, and increased jobs that we all desire. Industrial Energy Consumers of America supports the Smart Energy Act for the following reasons. First, for some time now, manufacturing investment in energy efficiency has been mostly relegated to small capital projects. Large capital projects that offer significant potential energy efficiency gains are rare. We believe that federal and state policies are part of this reason. Section 201 of the bill requires the DOE to examine a variety of potential barriers and provide guidance on how to fix them. Second, history can provide a good policy lesson on what works and what does not. Provision I, the bill requires that the DOE provide examples of past successful federal and state policies that result in greater use of industrial efficiency. Third, some countries have placed a high priority on improving manufacturing energy efficiency and competitiveness. We believe it's important to learn from what other countries are doing. Provision II requires that the DOE to examine cost-effective policies used by foreign government to foster energy efficiency. Fourth, federal energy efficiency matching grants are a policy favored by industrial sector. The matching grant program is a powerful economic leveraging tool that encourages manufacturing companies to open their wallets and spend capital on create jobs and help drive economy. Provision C would require the DOE to estimate the benefit of the national economy of such programs. Fifth, Section 203 would require the DOE to develop strategy to double the CHP and waste heat recovery capacity by 2020. The CHP technology can produce power at up to 80% energy efficiency versus the base load power plant at about 34%. The use of CHP and waste heat recovery projects can significantly improve competitiveness in a manufacturing facility. However, since 2005, almost no industrial CHP facilities have been built because of electricity market barriers. We welcome the DOE strategy. In closing, these provisions are being opposed by some organizations representing the electric utility industry. For absolute clarity, they represent those who are not only benefit from the barriers that are also in place, but foster from them. The provisions of this legislation do not change any regulations. All they do is to seek to identify and explore remedies. Congress should not be deterred from supporting transparency. Thank you, and I welcome any questions.
Thank you. Mr. Dries, you're recognized for 5 minutes.
Yes. Well, good afternoon, Chairman Whitfield and members of the subcommittee. I appreciate the opportunity to testify today. My name is Jeff Dries. I'm the U.S. Country President for Schneider Electric, and we are all about our global specialist energy management, and our business is all about energy efficiency. So we have 18,000 people in the U.S. and energy experts that every day when they wake up across 240 locations, they think about energy in the ways that make it safe, reliable, efficient, productive, and green, and that's the mantra within inside of our company. As I said, we're all about energy efficiency as part of our business. We are members of the National Electrical Manufacturers Association. We're also members of the Industrial Energy Efficiency Coalition and the Federal Performance Contracting Coalition. We commend Congressman Bass and Matheson for authoring the Smart Energy Act draft bill, which really takes a lot of first critical steps to prioritize energy efficiency within the construct of the national energy policy. And I just wanted to reflect on three pretty key points regarding the Smart Energy Act. The first one is more about how energy efficiency is the first fuel and also a job creator. The second one about how the federal government has an opportunity to take a leadership position using energy savings performance contracting as a means for energy efficiency. And the third point that I want to talk about is how energy and efficiency for the industrial sector can be used as a competitive advantage. The first point around energy efficiency as the first fuel, it's fast, it's economical, and it's the most effective way for governments, businesses, and individuals to minimize the uncertainty in energy costs and also improve the reliability of the grid and shrink dependence on foreign sources of energy and reduce our carbon footprint. We also believe that there's a strong investment needed in energy efficiency that can serve as a catalyst for job creation and continue to promote economic prosperity. Quite simply, it saves energy, it saves money, it drives new technology, and it makes energy for business like ours more predictable and managed as we manage our business going forward. Also, in this part around how it really can be used as the first fuel, this is a time for government and industry to come together, to really come together for the right conditions to create clear, predictable, long-term economic motivations that empower businesses to invest in cleaner, more efficient energy future. The second point around how the federal government can take a leadership role, we all know certainly that the federal government's under tremendous pressure, tremendous fiscal pressure, and we look for ways to saving energy and managing costs. And really, the federal government is the world's largest consumer of energy at $7 billion annual in energy costs. There's an opportunity here for the federal government to walk the talk, to really use this as one of the most effective ways to establish energy efficiency as a national priority and drive innovation that leads to cleaner and lower cost infrastructure. Section 101 of the Smart Energy Act requires federal agencies to use private sector financing, including ESPCs, to meet the energy efficiency mandates. This prioritizes the use of private sector financing over appropriated funds. A good opportunity here is it not only will create jobs and drive energy efficiency when you use ESPs, but let me be pretty specific. We're also members of the National Association of Energy Services Company, and they state that every $1 billion worth of performance contracts leads to 11,000 jobs. In fact, to date, because of ESPCs, more than $5 billion worth of equipment has been installed at no cost to the government, and $1.4 billion of savings have been generated with no capital outlay by the federal government. As an example, our project with the U.S. Coast Guard in Puerto Rico netted $22 billion worth of equipment, 53% of energy savings, and 270 jobs, just on one example working with the U.S. Coast Guard. Final point around how industrial energy efficiency really can drive manufacturing competitiveness. You know, our industry is a strong supporter of moving for a much more efficient industrial sector. We're a founding member of the Industrial Energy Efficiency Coalition, and we know as a manufacturer having 40 plants across the U.S., we know that energy efficiency is at the heart of one of the challenges facing manufacturing, which includes also reducing production cost, complying with new regulations, and reducing its environmental impact. The industrial sector consumes more energy than all sectors in the U.S. And while industrial facilities have large industrial facilities that consume large amounts of energy, have advanced energy programs, but out of the more than 200,000 manufacturing facilities in the U.S., more than 80% don't. And what we want to propose with Bass Matheson is that the expansion of the study to include not just the high-end energy-consuming industrial plants, but also all cross-section of all plants that need help, that don't have the level of sophistication that maybe a St. Cobain would have about how do we actually get in and help these customers, incentivize them to move for a much more energy-efficient industrial setting. We're very strong and bullish around combined heat and power, but we think some of the opportunities in the legislation is, you know, how do you use something like ISO 50001 as a national energy standard, just like ISO 9001 is a standard for quality, using the same kind of rigor and auditable energy results for industrial setting, just like we do with 9001 in quality, as well as enhancing the workforce development and really providing more education for federal government around and working with energy services companies on how this can be used as an opportunity to really free up energy savings and drive capital improvements in buildings. And just in closing, as a leader in the energy efficiency field, as a leader in energy management, I really appreciate the opportunity to testify. I look forward to answering any questions, and we stand ready to assist in this important legislation. Thank you.
Thank you. And Mr. Nadel, you're recognized for 5 minutes.
Okay, thank you very much, Mr. Chairman. Thank you very much, Mr. Chairman. Yes, my name is Steve Nadel, and I'm the Executive Director of the American Council for an Energy Efficient Economy. We're a nonprofit research organization formed in 1980, and just a couple of years ago we celebrated our 30th anniversary. We're a nonpartisan organization. In our view, energy efficiency is the quintessential nonpartisan issue. This is illustrated by the Smart Energy Act that is before us today. We thank Representatives Bath and Matheson for introducing this bill and hope that the Energy and Power Subcommittee and the full committee will report it out favorably soon. I have a few points I wanted to summarize here in my oral comments. First, energy efficiency is a key energy resource for the United States. As discussed in my written testimony, energy efficiency savings since 1970 make energy efficiency our #1 energy source today. This is shown by improvements in energy use per dollar of GDP, which have declined dramatically. Studies by McKinsey and Company, as well as our own organization, ACEEE, show that further cost-effective energy efficiency opportunities can reduce U.S. energy use by 20% or more. The costs of energy efficiency are generally lower than other resources and with a higher macroeconomic multiplier effect because energy efficiency tends to be labor-intensive rather than capital-intensive. Unfortunately, the United States is now lagging behind many leading countries in energy efficiency, which increases waste in our country and the cost of American goods and services. Just this morning, ACEEE released our first international energy efficiency scorecard, which compared 12 of the world's largest economies on 27 different metrics dealing with energy consumption and energy policies. Across the 12 countries we reviewed, the United Kingdom came in first, followed by Germany, Italy, and Japan. At our press conference, we had the United Kingdom's ambassador to the United States, who talked about how his government really views energy efficiency as a key strategy for helping to make them more competitive. And he talked about the many business-friendly and low-cost policies that they are adopting to help further energy efficiency in their country. The U.S., unfortunately, was 9th on our scorecard, far from the global leader we aim to be. We were 4th on building efficiency and 6th on industrial efficiency, so pretty good there, but we really did lag on transportation efficiency. If we are to fully compete with other countries, we need to redouble our efforts to be more efficient. A good place to start is the Smart Energy Act. This act will have a variety of useful provisions. It recognizes the importance of energy-saving performance contracts, as several of the other witnesses have described. It reduces energy use for data processing. It sets a goal of doubling amount of electricity from combined heat and power, which we agree with the other witnesses is a very important source of additional power and efficiency. And it requires a study on ways to reduce barriers to the deployment of industrial energy efficiency, and we agree there are large opportunities there, such as through much wider pursuit of use of ISO 50001. However, while this bill does contain many useful provisions, much more can and should be done. In my written testimony, I suggest 5 possible additions to this bill. Just to summarize 1 or 2 of those now. First, support for model and state building codes. National model building codes are developed by 2 nonprofit organizations. DOE provides technical assistance to these bodies and also assists states with considering whether to adopt these codes. We recommend that DOE set energy-saving goals for the model codes to help guide their development. We also recommend that DOE expand its work with the states to assist them to adopt and implement these codes. Second suggestion has to do with building training and assessment centers. Presently, a very effective program the Department of Energy has, a very small program, just a few $1 million, is to work with professors at universities to help train engineering students in industrial energy auditing techniques. They do audits of small and medium-sized firms, helping those firms to reduce their energy use, and the students get very valuable job training. In fact, upon graduation, they usually have multiple job offers. We recommend that this program be extended to the building sector and not just the industrial sector. Now, ACEEE in May published an analysis of the costs and benefits of a bill with provisions very similar to those of the Smart Energy Act, as well as some of the enhancements that we recommend. We found that such a bill would reduce U.S. energy consumption in 2030 by about 2%, and that would drive annual consumer energy cost savings of about $23 billion. Furthermore, based on our detailed macroeconomic analysis, we estimate that such a bill would create about 100,000 jobs by 2020 and about 185,000 jobs by 2030. So in conclusion, I would say that energy efficiency is a key part of all of the above energy strategy. Energy efficiency has reduced U.S. energy use substantially, and much more is possible, and that the Smart Energy Act is a very good place to start, and we hope you will report it out favorably. Thank you.
Thank you very much. And Ms. Callahan, you're recognized for 5 minutes.
Thank you. Thank you, Chairman Whitfield, for holding this hearing today and giving me the opportunity to testify in strong support of the Smart Energy Act. And as a fellow native Kentuckian, my gift to you is going to be to try to be very brief so you can wind down the afternoon. I am Kateri Callahan. I serve as the president of the Alliance to Save Energy. The Alliance is a bipartisan nonprofit coalition that's made up of over 160 different businesses, organizations, and institutions. They span every sector of our economy, and they come together to promote and drive energy efficiency worldwide. We were founded in 1977 by Senator Chuck Percy, a Republican from Illinois, and Hubert Humphrey, a Democrat from Minnesota. And we've been working these last 35 years tirelessly to not only advance energy efficiency, but to do so in a way that drives productivity and stops energy waste. We're delighted to count 3 members of this committee as our honorary chairs, Dr. Burgess, Mr. Bilbray, and Mr. Markey, speaking to the wide array of political interests that we can attract. They join 16 other members of the Senate and House who serve as honorary members of our board. On the Smart Energy Act and energy efficiency policies like those contained in the Smart Energy Act, we see those, as many of my colleagues here have said, as the cheapest, the quickest, and the cleanest way to address the economic and security threats that attend to our current wasteful consumption of energy in this country. Steve mentioned that we've made a lot of progress through energy efficiency. Our studies indicate, and then in large measure it's because of public policy, that today we're offsetting the need for about 50 quads of energy. Well, what is that? That's about half of the energy that we use. More important than just saving the energy is how much money that translates into. Our studies show that American governments, consumers, and businesses are saving $450 billion every year because of the progress that we've made on energy efficiency. So national policies, like requirements for improved federal energy management that you find in the SMART Act, to appliance standards, have important and proven benefits to our country. And that's recognized not just by nonprofit groups and advocacy groups like Steve Nadell's and mine, but I have here 52 pages representing 26 reports from organizations as diverse as the National Petroleum Council to the Business Roundtable to Deutsche Bank and on, stating the benefits, the clear benefits of national energy policy to our country. So I won't go through those because I think a number of them have been discussed already in this hearing, but I would like this put forward and into the record if I could, please.
Yes, it'll be admitted to the record.
Great. The Alliance commends both Congressman Bass here today and Jim Matheson for their leadership on the Smart Energy Act. We see this bill as standing as a testament to the fact that energy efficiency is an issue that draws support not just across political boundaries, but also from all regions of the country and all quarters of our economy. The legislation is supported by scores of business and organizations that don't often find themselves on the same side of the page. We submitted for the record a letter of support from 60 different businesses, and you'll find on that the U.S. Chamber of Commerce side by side with the Natural Resources Defense Council. This is a bill that enjoys very wide support. How did they do this? They're using low to no cost and common sense policies that are going to lower federal energy bills, and that's going to benefit taxpayers. As Jeff noted, they're creating good-paying jobs through greater use of ESPCs, and they are creating government and private sector partnerships, as noted by Mr. Marone, that are going to drive efficiency into the manufacturing sector and therefore enhance our global competitiveness. So at this time in our economy, when too many Americans are suffering financial hardship, energy efficiency, we believe, can add much-needed relief. American households, our studies indicate, are spending about $5,500 a year on energy costs. That's increased by 14% in just the last 2 years in this very bad economy. These costs are of greatest concern to low-income households, where they can gobble up as much as 20% of the family's monthly incomes. Bass-Matheson does not address the residential sector, but you have another bill before you by Mr. McKinley, the Homes Act, that would provide rebates to consumers for comprehensive energy efficiency upgrades. We support that bill and put it forward to you and commend it to your consideration. So as we struggle, as you struggle really, to find ways to put Americans back to work, we think energy efficiency offers a path forward. The Brookings Institute released an assessment last year that indicated that in 2010, the energy resource efficiency segment of our economy accounted for 830,000 of the jobs nationwide. And as you seek to right the America's economy, we believe investment in energy efficiency should be a top priority of this committee and this Congress. With government assistance, McKinsey Institute has said, in a significant investment in energy efficiency, we could save $1.2 trillion in avoided energy costs just between now and the end of the decade. So the Alliance views the Matheson proposal really as an across-the-board win for America, and we urge you to approve it quickly and get it to the House floor. We are not kidding ourselves. This is not everything that the efficiency community wants in terms of national energy efficiency policy. Absolutely not. But it is absolutely a good move forward, a very meaningful bill, and will benefit all of America. Thank you.
Well, thank you, Ms. Callahan, and thank all of you for your testimony. I want to thank you for also bringing to our attention this International Energy Efficiency scorecard, which I guess was released today. Is that right?
Yes.
And so were any of you surprised that the U.S. was that low out of the top 11 or 12 countries?
We hadn't expected the U.S. to be quite as low when we began it, but we let the data fall where it will.
And why do you think we are that low?
A couple of reasons. It's all relative to other countries. I would say most other countries have concentrated much more on energy efficiency than we have. You know, they have cabinet meetings on it. They have major national policies. As you and everybody else in the committee knows, we've had great difficulty reaching agreement on an energy policy in the United States.
Yeah.
And as a result, much less happens.
Plus, we so focus on production, and efficiency probably is the easiest and best way to improve our situation. Yeah. And as someone who doesn't know a lot about efficiency, I would like to ask you, Mr. Dries, you had mentioned a project I think that you all had in Puerto Rico.
That's right.
And you were talking about the astounding improvements that were made there. Could you just list a few things that you did there, practical things?
Some of the things we did. I mean, first of all, we installed a pretty significant renewable solar array on the rooftops of many of the buildings in the Coast Guard. They get about 25 cents a kWh in Puerto Rico, so it made it very economically viable to put in solar. Also lighting.
25 cents per kilowatt hour?
25 cents per kilowatt hour, right. Across the U.S., the average is somewhere around 10 cents per kWh in comparison to 25.
Yeah.
So along with that, we had lighting and lighting control. Also, a big part of the mechanical retrofit around cooling. So for that particular site, in many locations, cooling represented around 40% of the total energy consumption for that customer. So we redesigned, put in a central plant, and completely reconfigured and paid for the saving, or paid for all that with the savings generated. So it was lighting control, solar, and a complete redesign of their central system for cooling.
I'm assuming that at the DOE, the amount of money available for efficiency efforts would be minute compared to a lot of other funds that we have. Would that be correct?
Be correct. But
okay.
that's I think that's why we advocate ESPC so strongly, because there's no appropriated funds needed to really drive the project. Right. It's all leveraged from non-appropriated funds.
Now, I haven't talked to anyone at DOE about Mr. Bass's legislation personally, but I've been told that they don't want to take a position on this bill. Have any of you had any conversations with anybody at DOE about this legislation?
We've had conversations about similar legislation, companion legislation in the Senate. And I think that it would be fair to say, I won't speak for the administration, but that the kinds of approaches that are in the bills are very much in line with what the administration has been pursuing. The administration is trying to bump up the use of ESPCs. The administration is trying to drive greater efficiency into its own building stock. Forming partnerships with the private sector is something they want to see. And I would say, too, that there isn't enough funding for the programs at DOE, in our opinion. You could double it, and for every dollar that goes into DOE programs, it returns $17 or more in savings and sparks $10 or more in private sector investment. So it's a very, very wise investment for our government.
We should have given you all the Solyndra money, right? But okay, so philosophically, from your conversations, you're not speaking for the administration, but philosophically, you feel they would be comfortable with this approach?
Very much so.
Okay.
And this approach, again, on the Senate side, don't want to talk about that too much, but the vote in the Senate Energy Committee was 18-3 in favor of the bill. So it's got wide bipartisan
Yeah.
support there, and I only mention it because there's more of a track record than we've got on Bass-Matheson over here.
Is there any one thing that if you could put it into the Bass bill that would just kind of jump out that a provision you might put in to make it even better than it is? Can you think of anything offhand?
Well, I think it is about the prioritization of the ESPC language, because right now I think it's viewed as it's currently available, but why is it not being deployed? And if you look at some of the statistics around the ESPC program just in the last 3 years, there's only been 47 projects deployed. For us to meet the $2 billion initiative from Better Buildings, we need roughly 50 to 60 projects per year. So really making it a priority as the first fuel, as I mentioned, making it a first priority to do energy efficient projects with ESPC really is, I think that's what's
Okay.
I think, and Steve mentioned a couple of things that maybe I'll just re-emphasize here. One of the things that other countries and businesses have done that drive efficiency and that would pull us up, they set targets, and then they go about trying to meet those targets. In the Senate version of the bill, it establishes a process for setting national targets for building energy codes, so improving those codes over time. The residential and commercial stock uses 40% of the energy consumed in this country. So putting that in place, and it also gives not a lot of money, a very small amount of money, but it gives money to states to have them go out and adopt the current codes and then enforce them and get compliance with the codes. So if I had another add to and a wish list, that would be my top priority.
Okay. Anybody else have any?
I would agree with that. In our analysis, the savings from all of these provisions, the building code provision had by far the largest savings. We're a data-driven organization. When you have that much savings, that's the top of our list.
Okay. Okay, Mr. Olson, you're recognized for 5 minutes.
I thank the chairman, and a belated welcome to the third panel. We greatly appreciate your stamina, your persistence, your willpower. I apologize for the votes, and I was going to ask 30 minutes of questions, ask unanimous consent, but I'll only stick with the 5 minutes allotted here. My first question is for you, Mr. Maroney. Your testimony shows that 5.5 million manufacturing jobs in thousands of manufacturing facilities have been lost since 2001. I'm concerned by Exhibit C of your testimony, which shows that almost no industrial combined heat power facilities have been built since 2005. Why aren't these facilities being built? You mentioned electricity. You said electricity market barriers. What are those barriers?
I think there's a combination of issues, but I'd key on two. One is accessibility to electricity markets, and the fact that if you believe that there's discrimination about getting access, the onus is on the manufacturer to prove otherwise, and that's a very timely and costly process, and they're probably not going to take that route. Another area of concern is the lack of long-term contracts. Without a long-term contract, there is a high financial risk that manufacturers do not want to take.
Are these barriers in federal government barriers, market barriers?
I think they're market barriers through the Energy Act of 2005 and for other things that have taken place that make it very difficult.
Anybody else want to comment on those issues? Ms. Callahan?
I can add something. A lot of it has to do with how utilities price power and provide access and what state regulators permit or do not permit. It's probably more a state issue than a federal issue.
Federal issue, okay. That's kind of what I suspected. And I'm also intrigued, Mr. Chamberlain, by the University of New Hampshire. Congratulations on your cogeneration activities up there. Tell me, why did the university choose to invest in cogeneration technology as a means for the campus's energy needs?
It was a combination of the right time. We had a very aging boiler plant. It was a single-purpose plant. That plant converted about 80% of the fuel energy into usable thermal energy for heating the campus. But we were importing all of our electricity. And when we ran the numbers, rather than investing in that 50-year-old technology, we ran the numbers and we realized that we could increase the efficiency with which the total fuel energy, in other words, the fuel that the power plants were also using in their single-purpose plants, which was converting roughly 35% of the fuel energy to electricity. We could substitute our own system, and we could achieve about an 80 to 85% efficiency in converting fuel energy to usable energy to meet campus needs. So much more efficient. We also gained a significant reduction in emissions, pollutants. We reduced our greenhouse gas emissions, and at least in the 2011 data that we've looked at, it saved us about $3 million.
Are there regulatory burdens that we need to address so other companies, other universities can use your example for that?
I think there are two things that I would offer to the committee to consider, at least in our experience. We found that for Clean Air Act enforcement and for air permitting, the regulators are restrained to look only at your site. So we were lucky because we already had a major power plant, and as part of our conversion, we were switching from using heavy oil, number 6 oil, which is one step up from road tar, to natural gas. So that actually was a big contributor in letting us lower our total emissions. But if I were an industrial site and wanted to install cogeneration, and I knew that I was going to reduce the load on the grid because I was going to make my own power, the regulators have to look only at my site. And I'm going to be increasing the emissions from my site. And yet they can't look at the regional benefits.
Yeah.
So I think that's an issue that needs some consideration because it could potentially become a barrier to someone who wanted to move forward with cogeneration.
Yeah, as we see up here in Washington, we need to stay in the real world sometime and not just focus down on one microcosm of the real world. And my last question for you, Mr. Dries, I'm not too familiar with ISO 50,001. And so tell me how this works, and what's the advantage of adopting it?
So ISO 50001, if you think about, in the manufacturing environment, how quality really needed a standard just 25 years ago, there really wasn't a sense of, how do you drive quality, how's there a standard process? So ISO 9001 was born, and hence now you can come into any facility that's ISO 9001 certified, and the quality standards that location adheres to. ISO 50001, we're saying there needs to be a same audible path for energy management to say it's about how many BTUs, how many energy consumption per square foot is this facility. If you have a corporate sustainability report, how you tie it back all the way to the utility bill that shows that you're actually reducing the energy footprint of that site. ISO 50001 puts audible measurements in place for any facility, just like ISO 9001 did for quality. So it's applying the same kind of rigor that manufacturing environment is used to for quality. Let's apply that for the energy efficiency standard.
Mr. Chairman, I'm out of time, and for using our Navy terms, you can, at your convenience, let the panelists clear them to go ashore.
Well, thank you, Mr. Olson. As you all know, Mr. Bass introduced the legislation that we're discussing today, and we have as a matter of policy that the person that introduces the legislation has to go last, and so when you have a 6-hour hearing, that's how you determine how committed they are to their bill. So now we recognize Mr. Bass.
Mr. Chairman, thank you, and I have had more fun listening to the Solyndra debate. I've been waiting for weeks for this hearing. I want to thank you again for giving me special dispensation here to participate in this hearing and ask a few questions. First of all, and I don't want to lead these witnesses too much, can either you, Mr. Chamberlain, or Mr. Marone, give us an idea, or any of you, give us an idea as to exactly what the savings are through the utilization of combined heat and power? I'll lead you a little bit. Electricity generation, what % efficiency? Thermal generation, what % efficiency? Combined heat and power, what % efficiency? And what, if any, are the savings in terms of big macro numbers that this nation could see if we were to increase cogeneration significantly?
I can't give you exact numbers. Reason being is that I said we have 260 facilities in North America and Canada, and I would say certainly in our energy-intense facilities, we're about 50% of them have some form either in the drawing board or being implemented or fully implemented. I can tell you that in energy efficiency, on a spend of about $400 million a year, we're easily saving $10 to $13 million a year. So it's a significant number.
Mr. Chamberlain?
Our experience, well, the efficiency issue, standard single-purpose electric plant converts about 35%. A standard boiler plant roughly 80%. For a typical installation like the university where you're producing your own heat, you're buying electricity, that nets out at about 50% of the fuel energy is converted into usable forms. So there's a huge increase over that 35%. I'm sorry, if you go to cogen, you can get to 85%.
That's right.
So there's a huge increase in the efficiency of the fuel conversion. And so in terms of national impact, the more of that we can do, clearly the better off we're. The available energy sources are going to go further.
Roughly 35%, 50% thermal, about 85% total.
Cogen.
So the savings are gigantic. Mr. Dries, what, in your opinion, is the biggest barrier to the use of energy savings performance contracts in the federal government?
I think the first thing I would say is probably just knowledge. It's a different way of doing business. So it's not like your traditional hire an architect, hire a consulting engineer, go through the normal construction chain. So it's a very different process because it uses design, build, energy performance criteria to justify the project. So it's a very different way of doing projects. So I think one of the gaps we have is how we educate the agencies on exactly how this process works. Right now, that's one of the things that we really should push is to shorten the amount of time. You know, we can get to 60 projects a year. We've got to shorten the amount of time the companies get selected, shorten the amount of time the audits take place where you can actually get it to contract.
How do you think the bill would help?
How in the bill would it help?
Yeah. How would the bill help?
Well, if you, so basically today,
overcome these barriers.
Today's status quo doesn't work. So
why not?
I talked about current state of only 47 projects over 3 years and $800 million worth of projects. And we know there's roughly $1 billion in savings potential in the federal government. If it's a priority, it makes it as the first method of reducing energy efficiency. We now know the agencies have to rely on that. And it's gonna drive some innovation. It's gonna shorten the cycle time to do these projects. So by putting it as the priority, we know it will drive the numbers that we're talking about.
I put it in a simpler maybe way. It takes the risk out of it for the agency managers. I mean, I think that's a lot of it's an education and it's a risk. They're not going to be paid anymore if they do an ESPC. There's risk involved in it, and if the Congress is directing them to use this as a priority, it removes the risk, and we think will open up the flow of projects.
Last question for Mr. Marone. How do you think that combined heat and power can benefit this domestic economy and create jobs?
Well, anything you can do to create efficiency, you know, it's particularly in energy. It's going to put more working capital to other projects. We reduce or increase our savings. We're going to hire jobs. We're going to increase profitability. We're going to increase sales. We're going to increase the economy. Anything in light of CHP or anything else close to that, any energy efficiency initiatives, will only serve to improve reliability to the grid. It'll serve to create jobs and stimulate the economy.
And lastly, Mr. Rohn, and briefly, can you elaborate on why industrial energy efficiency from a cost management perspective is critical to our nation's manufacturing process?
I guess maybe a simple way of saying I look at energy efficiency as I look at safety. I think we have to look at a cultural transformation. As businesses and organizations look at safety in the workplace for their employees and their factories, we have to think in the same light and maintain the same mentality when it comes to energy.
Okay, thank you very much. And Mr. Chairman, one last little request. I have here letters of support from the American Chemistry Council, the National Association of Manufacturers, and the National Electrical Contractors Association. I'd ask unanimous consent that these be entered into the record. And I thank the chairman for his time and his indulgence.
Well, thanks for staying with us. We appreciate it. And well, that will conclude today's hearing. Once again, thank you very much for your time, your commitment. I do apologize it took so long, but all of your testimony has been read. We have it in the record, and we look forward to working with you as we take steps to try to improve this nation's efficiency. And the record will remain open for 10 days for any additional material. So that concludes today's hearing. Thank you.
Thank you.